Everyone, welcome. Let's call this hearing of the Assessment Appeals Board to order for August 15th, 2016. And we'll start with a roll call.
Board Member Crow.
Present.
Board Member Curtis.
Present.
Board Member Stern.
Present.
Thank you.
Great, thank you. And now I'll ask that everyone please stand for the Pledge of Allegiance. And if you intend to provide testimony, please remain standing, and you'll get sworn in right after. Okay, ready you begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great. And if you do intend to provide testimony, please stand so that our clerk, Mr. Vlahakis, can swear you in.
Anyone that will be addressing the board today, please stand. Will you be addressing the board today? Please stand. I'll now place you under oath. A complete reading your oath is stated to you. You and each of you do solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you.
Okay, great. And next is our agenda review, which will group some items together for efficiency with one motion. Do we have any?
No, unfortunately, this agenda is too short. We do not have an agenda review this
I
morning.
keep looking for the rest of the agenda. Okay, great. And we'll go next to public comments. So this is a time for anyone to make a comment on a non-agenda item. Okay, hearing none, we'll go to board comments. Okay. Moving right along, we'll go to our first application, items 8 through 16 on the agenda, applications 15-11581 through 89. Applicant is Elizabeth Trangello.
Ms. Trangel, if you'll please come take a seat here, and I'm going to just hand out some copies of this application to the board.
Looks like we have a request for reconsideration of a withdrawal.
Correct. And I'm not recommending we do an agenda run-through necessarily because we only do have 2 items. So I'm just suggesting we go right into this one. It should be very quick.
Okay.
So I'm going to hand out packets to the board.
Thank you. Okay, should we get an overview from you, Mr. Vlahakis,
Yeah,
first?
I'll give a quick overview. This is a request for reconsideration of a withdrawal. And I've passed out copies of the application submitted by the applicant, their notice of hearing on for April 26th, their request to reschedule to May 24th, their notice of hearing for May 24th, withdrawals received for each application. They were submitted to the assessor's office on May 11th and forwarded to the clerk of the board's office on May 16th, as shown by the date stamps. And a written request for reconsideration from the applicant explaining why she'd like the board to reconsider her case, and then the notice of reconsideration hearing, which on its backside explains what the board will be able to hear for the benefit of the applicant. And so just to finish off my overview, I'll read the notice of hearing, which will pretty much explain what the board is here to do today. This hearing has been scheduled so that the Assessment Appeals Board can consider the applicant's request for reconsideration. Subject applications were withdrawn on May 16th, 2016, which was 8 days before the scheduled hearing for May 24th, 2016, regarding valuation. The applicant is asserting that she did not clearly understand what she was signing when the Assessment Appeals Board, when the assessor's staff gave her the withdrawal documents and asked her to sign them. The Assessment Appeals Board's policy on withdrawals, adopted July 17, 1995, indicates that withdrawals are effective and final when entered by the clerk. I do have a copy of that policy if the board would like to examine it further. The policy more specifically indicates where notice of request for withdrawal has been given or made by the applicant and entered by the clerk, the matter with respect to which the application was filed is deemed concluded and there is no reconsideration. However, as noted on the withdrawal form, the board is given authority under Revenue and Taxation Code 1610.8 to hear and determine any assessment on which an application has been filed. As well, the California State Board of Equalization also instructs that it is inappropriate for assessor staff to ask for withdrawal forms to be submitted to their office directly, as it could interfere with the applicant's right to an independent review by the Assessment Appeals Board. We also have a copy of that Board of Equalization recommendation if the board would like to review that. The board will consider information related to reconsideration of these applications and determine a good cause has been met. If they determine good cause has been met, been demonstrated, I apologize, and the board has the authority to reopen the applications, evaluation hearing would be scheduled for a later date. Although the board's policy says these are final, we consulted with county council, who recommended that we schedule this for a reconsideration hearing, which is why the matter is before you today. And that is all the information the clerk has.
Okay.
Mr. Chairman, may I comment?
Sorry.
Okay.
I just learned that, so.
Okay. We opined that in order to ensure due process for the applicant, based on the applicant's handwritten statement of May 26, 2016, that the applicant have a shot at explaining the applicant's position as to why the applicant signed the withdrawal forms, if that's not what she intended to do. It's the board's ultimate determination on whether or not to grant relief from the withdrawal or not. That's entirely the board's decision, but I felt it would be beneficial for the applicant to at least have a shot at explaining the applicant's position, and then the assessor can, if the assessor disputes the applicant's description of events, then the assessor can certainly present a witness on that too. But the final call's the board.
Okay, thank you. So I think best way might be for us to proceed, just for the board's benefit, before we hear from the applicant. The third page from the back of the packet that we have is a handwritten explanation from the applicant. I thought it might be a good idea for us to be able to review that for a minute, and it might help us ask questions if we have them from the applicant, and then we'll hear from the assessor with any comments and go from there. So let's just take a minute, if we could, to review that. Okay, so let's, unless there are any questions or comments first from the board, we'll go to the applicant and hear some information. Trangelo, am I pronouncing your last name correctly?
Correct.
Okay,
Yes, sir.
Great.
Thank you.
So if you could please state your name first for the record, and then just give us a brief explanation. And just to remind you, what we don't want to do right now is go into any of the details of the valuation, just kind of the process that's led you here to request the reconsideration.
Okay, good morning, sir, ma'am. My name is Elizabeth Trangelo. I live in this house, and this is a house of my mom, but when she passed away, she want me to give it to my son and my niece. So I've been the one paying for the property tax since my mother passed away in 2005. And like what I said, I just want to ask if the board could lower down my property tax, because from 1,700 it jumped up to 4,200, which I couldn't afford.
Okay, thank you.
Thank you.
Are there any questions from the board at this point?
Your mother passed away, and
2005, sir.
it was that
It's in a trust.
it is in a trust.
Yes, sir.
Chairman Stern, if I could ask a question of the applicant that I think might matter. Could you please explain to the board why you signed the withdrawal forms and why you would like them to reverse the withdrawals? That's what the board is trying to determine right now, is if they can reopen your cases and because of your confusion with the withdrawal forms. So if you could please explain that to the board.
Okay. I signed so different pages because I did not understand why he wants me to withdraw. He said that this is a waste of time, that they're not going to lower down your property tax anyway, so just sign this and go hire an attorney to help you lower down the value of the property. But my lawyer said I cannot do that. There's nothing I could do to help you. So I said, what did I do? Why did I not have the appeal? So that way the board could listen to my opinion. You know, the house is very old, it's older than me, and the property tax, why did it jump so high?
Okay.
You know, so I would like, please, to have the appeal. Then maybe you could give me the consideration to, if I won't go back to the same property tax, which I pay every single year,
Okay.
even though it goes up.
So I have a question for county council. Are we able to do this?
If the board, on hearing testimony from all parties, determines there was some kind of fraud in the inducement to have someone sign the withdrawal papers, then they wouldn't be enforceable. Yeah, and so, but I don't think there's enough testimony yet, one way or another, for the board to make that determination. There's been no description of the conversation between the applicant and Mr. Denham. And was she given the forms? Did she have time to read them? Did she voluntarily choose not to read them and sign them? You know,
No.
that's the kind of information the board would need to elicit from the parties to find out whether or not the board wants to offer the applicant a chance to go forward, notwithstanding the fact she signed withdrawal forms.
Besides what the applicant has given us in this letter, handwritten letter, correct? Is that what you're saying? You
Yeah.
need more testimony?
If with the board's permission, I could ask the applicant a question.
Sure.
When you signed the withdrawal forms, was that during a meeting that you had with Mr. Denham?
Yeah, just him and me, but he didn't have me read even one piece of paper. He just say, here, sign this, and then flip, sign that, sign that. That's it. I don't know what I'm signing, but of course I remember he told me, go hire an attorney to lower down the property, the value of the property, didn't come back to me.
Did he tell you not to read the forms before you signed them?
No, he did not tell me to read or not to read. He just say, here, sign. And so I signed. I didn't read.
Has Mr. Denham been in your home?
I'm sorry, sir?
I said, is Mr. Denham been in your home?
No, sir. I would like them to come and see the house. The house is old. That's why I said, please send your man to come and appraise the house.
And when did you actually sign the forms? At your house or here?
Here at his office, right there in the...
Okay. So if we reconsider the withdrawal, you would like us to, as a board or a hearing officer, you would like us to reconsider the value of your property, correct?
Yes, please. Yes, please.
Okay, let's go next to the assessor to hear any information that you might
Good morning, board members, council. Christopher Horn for the assessor's office.
Morning.
There are two issues that were being dealt with regards to the application. One was the change of ownership as in 2005. The other is the subsequent year valuations. The assessor had two representatives, one Mr. Ekema dealing with the change of ownership, and the other being Mr. Denham dealing with the valuation issue. Mr. Ekema explained to the applicant that the change of ownership was going to stand because of the R&T code that says if you bypass a living relative to go from grandchild or grandparent down to grandchild, it's a reappraisable event. So,
Okay, but that's really the specifics of the case, correct?
Correct.
Okay.
that was what Mr. Ekema dealt with. Mr. Denham looked at the valuations and told the applicant, he had reviewed them, and he would not be recommending a reduction either on the base year value or the subsequent Prop 8 values that were established. It is my understanding through conversations with him that because we weren't looking to make a reduction, the applicant had the two choices, either to move forward or withdraw. The withdrawal forms were printed off, handed to the applicant at the counter. The applicant signed them, left them with us. We took them up to the board. And now we're here today due to the applicant deciding that after all was said and done that she wants to go forward. Her own testimony was Mr. Denham didn't say, read these, don't read these. It's
So
going to
just
be
a
up to the board to decide.
Okay. Thanks, Mr. Horn. So my interpretation is that the assessor is not agreeable or does not
No,
recommend
no.
a reconsideration.
That is not, we are not contesting it, it's the board's decision.
Okay.
If the board does decide to move forward and grant this, we ask that, because it's a hearing officer case, even though October is the next one, we're asking this get pushed to January because of the workload that exists already.
Okay. Thank you.
You said it was a hearing officer case?
Yes, sir.
The choice of the applicant?
Yes.
Okay. And is that your choice? If we were
To have a hearing?
hearing officer or in front of the board?
A hearing officer is just a single person, and the board is a full.
I think I would like to talk with the board, please. I mean, I don't know. This is my first experience, and I never heard anyone that have the same problem.
Okay. Sorry, I didn't mean to jump on your question. Any other questions from the board?
So because of this transfer bypassed this lady here, and it becomes a reappraisal transfer then?
Correct.
I have a quick question for our counsel. Ms. Porsche, you had mentioned that I think that you used the word fraud. So if the board determines that there was some kind of fraud, that it might be appropriate to reconsider. Is that the threshold for our consideration, or can we just make the decision based on our reasonable decision, or is there a threshold for a certain level of?
Ordinarily, the board's previous policy has been to consider withdrawals as something that aren't revisited.
Mm-hmm.
But in reading Ms. Trangello's handwritten description of the circumstances under which she signed the withdrawal form, it seemed that there was at least an open question on whether or not only did she do so unwittingly,
Mm-hmm.
but she did so somehow having been misled. It appears from the testimony that Mr. Denham presented the forms to her and left the choice to her of whether to read them or sign them
Okay.
without reading them, and she says she signed them without reading them. I'm going to leave it to the discretion of the board what they want to do under this
Okay.
circumstance. Since I've been here, we've not had a similar situation of an applicant saying, I signed these things, I didn't understand what I was doing. This is the first I've been presented with. It's up to the board's discretion how they
Okay.
want to respond.
Thank you. So let's deliberate quickly and make a decision. Sounds like our two courses of action are either to grant or not to grant the reconsideration. Any comments from the board first?
Sure, I'm in favor of granting it to the applicant. She seems, based on the letter, it seems like she was not understanding what she was signing, so basically, I would be up for giving her a chance to present her case on the valuation of her property in front of the board or hearing officer, either way, whatever you would enjoy. Choose.
I would support that decision, and perhaps the assessor will send a representative out to look at this property and see what condition it is for his opinion of value as such.
Okay. And for the record, I agree. I think it's worth the reconsideration. And so looking for a motion.
Just for the record, also, typically the assessor doesn't send someone out to people's homes. Their caseload doesn't really allow that, but they do a fairly accurate job of evaluating what they feel the property is worth. So I make the motion to grant the reconsideration of the withdrawal.
I will second that motion.
Okay, moved by Mr. Curtis and seconded by Mr. Crow, and the motion carries. So that is approved, and I think the next step would be to schedule a hearing date. Mr. Vlahakis, do you have any recommended?
I would recommend. Okay, I'd recommend continuing to February 13th, 2016, if that date works well with everybody. Or 2017, sorry, February 13th, 2017.
Okay.
That's in front of the board, correct?
Right. That would be Assessment Appeals Board number 2. We could do Assessment Appeals Board number 1 on March 6, 2017, if this board wanted to hear the case.
Okay, so let's go to the applicant first. Ms. Trangello, is February 13th an acceptable date?
Yes, sir.
Okay, and to the assessor?
The February date is acceptable. For clarification purposes, we're asking the applicant if she is contesting still the change in ownership, or if this is just valuation only, because we want to be prepared for one or both.
I could also change ownership because it's still in my mom's trust. So I'm just worried also, though, that after the appeal, after this appointment, in the future, if I must change the ownership because it's in my mom's trust, are they gonna reassess the property again, and my property tax will go up again?
I'm not comfortable discussing hypotheticals.
Yes.
At this point. What we're wanting to know is if you are in agreement that the 2005 death of your mother resulted in a change of ownership that triggered the revaluation. Are you in agreement, or are you going to contest the fact that that event triggered?
I would like to contest, sir, because
Okay.
in 2005, when she passed away, the value of the property are very high, and then it dropped in 2008. Did they? I wanted to know, did they also change? Did they lower down my property tax at those years also? That the values are low.
I think it's possible that that the applicant might need a little bit more information between now and the hearing date to really understand how the application might be best filed.
Chair
versus
Stern,
right now.
I agree with you. I believe we'll have a representative, Mr. Ekema, recontact the applicant and go through the explanation again
Thank
of
you.
what triggered all of this.
Thank you.
Thank you.
Thank you.
Okay, so.
So in the
Mrs.
interim, then, I think in order to preserve the applicant's full scope of her potential appeal, it all should be forwarded to February 13, 2017 as a continuance date with then, if there's subsequent agreement between the parties, they can knowingly withdraw that portion that deals with change in ownership, if that's the case.
Okay, thank you. And so we're looking for a motion to continue to February 13th of 17.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. So the hearing is now scheduled for February 13th.
Thank you, sir.
Okay.
Thank you, Mr.
Thank you.
Stern.
So again, please communicate as well as you can with the assessor between now and February to resolve any of your questions.
Okay, thank you, sir.
That's the key.
Yes.
Okay, thank you.
sir. Thank you very much, sir. Thank you, Mr. Curtis. Mr. Stern.
Okay, we'll go next to item 17, application 11-12146. Applicant is Garthorpe Inc. Everyone,
I'll give an overview of what we're going to be doing today once everybody's ready, unless you'd like me to start now.
okay,
Give us just a couple minutes, Mrs. Cole will be right back.
okay, sure.
Okay, got it.
Would the board like to take a 5-minute
Yeah, let's take a
recess?
5-minute recess. Thank you.
All right, we are back on the record.
Okay, we're back on the record, and we're hearing item 17 on the agenda, application 11-12146. Applicant is Garthorpe Inc. And I know that we've heard the issue before, and it looks like we are determining the classification of the property. Is that right, Mr.?
Correct. In your application packets, I provided the original application filed, the authorization of agent, the order of the Superior Court, and the notice of today's hearing. Just to start with the order of the Superior Court, the Superior Court has indicated you are hereby commanded forthwith to vacate and set aside your decision dated February 11th, 2013, related to application number 11-12146, and to conduct a full assessment appeals board hearing to determine the classification of the property identified as tax identification number 256LK, and the County of Ventura Assessment Appeals Board number 1 shall make findings necessary to determine the classification of the property. So first, the board will start by you receiving and filing the court's order to do so. And so at this point, we'd be requesting the board to make a motion to receive and file the court-ordered peremptory writ of mandate pursuant to stipulation, just to
Okay.
acknowledge it for the record.
Okay, first, are there any questions from the board based on Mr. Vlahakis' statements or from our counsel?
It
Okay.
appears in order. The board can receive and file.
Okay, so then looking for a motion to receive and file as stated by Mr. Vlahakis.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis and seconded by Mr. Crow, and motion carries.
All right, so the board will be here to determine the classification of the subject property as ordered by the court. I believe we can clarify this with each of the representatives, that the board will be determining whether or not this property qualifies for a business inventory exemption. If we could just confirm, is that what the applicant's parties are asking for?
That is correct.
And is that what the assessor believes today's hearing is about, is to determine if this property is classified as business inventory exemption?
That's correct.
Okay. Follow-up question to that, just for proper processing purposes to the assessor's staff, if the board was to determine this property did not classify as business inventory exemption, would there need to be a subsequent valuation hearing to determine what the valuation of the subject property is?
Mr. Clerk, my understanding is that there is no dispute as to the value. The value on the roll appears to be $19,044,900. The applicant has indicated zero because it believes that the property is exempt from property taxation. Mr. Rice can correct me if I think this is Mr. Rice over here.
It is, yes, I'm George Rice.
But I don't believe there is a dispute over valuation, so I
That-
think the only issue before the board is to determine whether or not to classify this aircraft as exempt under the business inventory exemption.
That's what my understanding is as well. I just wanted to verify on the record. If the applicants if the board determined the property was not exempt, would you be protesting the valuation total?
No.
Okay, so a subsequent hearing would not be required. That's why I wanted to clarify in case we had to bifurcate the hearing, get it all cleared out at this time. So like we said, the board will be determining the classification of the property, and I believe that the applicant's party has the burden of proof, but we can clarify that if needed.
Okay, thank you, Mr. Vlahakis. I'll start with the applicant, just in terms only of verifying burden of proof with the hearing. Is that, and if you could please state your name for the record.
My name is George Rice.
Okay, Mr. Rice is the applicant.
This is my colleague.
Vicky Baladian.
Your microphone's
Good
not.
morning.
For the applicant.
And does the applicant agree in terms of burden of proof lying with the applicant?
We accept the burden of proof.
Okay, great. And also, if you could state your name for the record.
Good morning, Mr. Chairman, members of the board. My name is Brett Price. I'm an attorney with the firm of Norman Dowler, and I represent the assessor in this matter. With me
Okay.
at council table is Ms. Brooke Hill, chief appraiser in the assessor's office.
Okay, thanks,
Miss-
Mr. Price.
Mr. Chairman, if I could ask a housekeeping question, just to clarify whether any party has requested written findings of fact for this portion of the determination?
We have not, but we certainly intend to. We spoke to Brendan about that earlier. I just need to write the check. I haven't done that yet.
Thank you.
Okay, and Mr. Price, the assessor, does the assessor agree in terms of burden of proof being with the applicant?
Yes, the burden of proof is with the taxpayer.
Okay.
And as far as the findings go, as long as the applicant has requested and paid for the findings, we have no issue. If for some reason they withdraw that request, the assessor will request findings.
Okay. Sounds good. Mr. Vlahakis, in terms of administration, we're good with the
That's good, yes.
findings of fact?
If the applicant's payment for some reason was not made before the conclusion of today's hearing as required, or for extreme example, the check bounce, we would be required to give the assessor the opportunity to request the findings once that, initial request has been deemed canceled. So I'll make sure to be on top of that.
Okay, great, thank you. So when we start with the hearing, we'll begin with the applicant's presentation. And then the assessor, the applicant, will have the last opportunity for a closing summary. Before we start, is there a brief overview in terms of or is it needed in terms of the history of what we've heard before from the assessor, or should we be okay with just proceeding?
We have an opening statement.
Okay.
Yeah, and we do as well, but we'll let, obviously, the taxpayer go first, and then probably reserve our opening statement to the beginning of our case in chief.
Chairman, sorry, I'd semi-clarify your question. The matter heard before and returned by the court was to determine if the property was, or if the board had jurisdiction to hear the issue. The court ruled that the board does. So that really has no effect on today's
Okay.
hearing. So it's
Got it.
not necessary. This is basically a completely new hearing on a different issue.
Got it. Thank you. Okay, let's start with the applicant's presentation.
Very good, thank you. Good morning. My name is George Rice. I'm the representative for the Garthorpe Corporation. We have a somewhat lengthy presentation today, and we hope that we have your patience. So this hearing today was previously scheduled for August the 6th of 2012. The original purpose of that hearing was to determine whether the aircraft should have been classified as consigned for sale on the January 1, 2011 lien date, and therefore exempt from property taxes for the 2011-2012 enrollment as business inventory. Prior to the August 6, 2012, and throughout the spring and summer of 2012, we as the representative of the taxpayer worked diligently and had considerable communications and meetings with the assessor's staff in an effort to reach resolution to this application without the necessity for conducting a full appeals board hearing. On February the 21st, 2012, the assessor made a 441D request for information, to which we responded on April the 30th of 2012. On June 27, 2012, the assessor made a formal request for an exchange of information under Property Tax Rule 313F, to which we responded on July the 15th, 2012. Also on June the 27th of 2012, the assessor issued a raise letter increasing the assessed value of the aircraft from $19,044,900 to $21,108,700. On June 28, 2012, the assessor made a second 441D request, to which we responded on July the 11th, 2012. As it became obvious that the assessor was not convinced of the merits of our position, we committed serious resources to preparing for the hearing, and by the end of July, we were prepared and had 2 witnesses scheduled to appear on August the 6th. On the afternoon of July the 30th, we received a telephone call from the assessor's staff indicating that the Chief Deputy Assessor had determined that our application could not be heard because the Appeals Board lacked jurisdiction over the issue of classification of the aircraft in question as business inventory. This change in tactic by the assessor, of course, was a surprise to us as the taxpayer's representative, especially after the extent of the information that had been demanded by the assessor in evaluating our application. We later learned that on July the 26th, the Chief Deputy Assessor had written a letter to this Appeals Board indicating his position in this regard. The taxpayer was copied on the letter, but our firm was not, despite the fact that we are the authorized agent for this appeal. Consequently, we were out of the loop and completely surprised by the Chief Deputy Assessor's newly stated position. In the same telephone call, the assessor's staff requested that we sign a waiver of the 2-year limit for this hearing because the assessor needed more time to prepare his legal brief. We signed the waiver, and the hearing was postponed until November the 12th. On numerous occasions during September and October, we contacted the assessor and requested access to the assessor's legal brief, wherein the position asserted by the Chief Deputy Assessor could be justified in the law. Upon arrival at the hearing in Ventura County on November 12th, we still had not been provided the legal brief upon which this lack of jurisdiction theory was based. Upon commencement of the actual hearing, rather than providing the Appeals Board with his legal brief, the assessor made a motion to the chairman that the burden of proof is on the taxpayer and suggested that we as representatives of the taxpayer should bear the burden to establish that the Appeals Board did in fact have such jurisdiction. The assessor's motion was accepted by the chair, and both sides made their case. As to jurisdiction, of course, we went first. On February 11th, 2013, this Appeals Board issued its findings and concluded that the assessor was correct and that the Appeals Board lacked jurisdiction of the classification issue in question. Faced with the knowledge that the taxpayer had been denied due process, we as the taxpayer's representative wrote to Mr. Dean Kinney, Chief of the Property and Special Taxes Department of the Board of Equalization on April the 15th, 2013, and requested his legal opinion regarding this issue of jurisdiction. On October the 23rd, 2013, Mr. Daniel Paul, Tax Counsel Supervisor, writing for the California Board of Equalization, responded and indicated that in his opinion, the Ventura County Appeals Board did have jurisdiction to hear our application, but indicated that his views were merely advisory in nature. On the very next day, October the 24th, and unbeknownst to us as the taxpayer's representative, Mr. Ken Kaiser wrote to the California Board of Equalization and requested a reconsideration of their opinion letter issued by Mr. Daniel Paul. On April the 7th, 2014, Mr. Richard Moon, Tax Counsel 4, writing for the Board of Equalization, reaffirmed the conclusion reached in the earlier letter by Mr. Paul, and confirmed that the Appeals Board does have jurisdiction over the classification of this aircraft. In August 2014, on the strength of the Board of Equalization's opinion, the taxpayer filed a petition for writ of mandate in Ventura County Superior Court. In May 2015, Judge Kevin DeNoce of the Ventura County Superior Court issued a writ of mandate commanding the Ventura County Appeals Board to set aside its decision dated February 11, 2013, and to conduct a full assessment appeals board hearing to determine the classification of the aircraft in question. That brings us to today. We appreciate the opportunity to present our facts. We believe we have a strong, compelling case based on unusual circumstances. After hearing our presentation and reviewing our exhibits and listening to our witnesses, we hope you will find the subject aircraft qualifies for the business inventory exemption with respect to the 2011 fiscal year. We appreciate the opportunity to be heard, and we ask for your patience in presenting our case. So with that, if we could pass out our exhibit binder, please. Thank you, Brendan. I apologize in advance. These binders are awkward. I didn't quite know how else to deal with it. Brendan asked me to try to package them in one group as best I could. I didn't quite know how else to do it, so I apologize. I understand they're awkward. So what I'd like to do, my presentation is organized as follows. My first 10 or 12 exhibits have to do with facts. Absolutely, what happened in this case. Then I have two witnesses that I'd like to call and interview two separate witnesses. And then we'll have another exhibit dealing with my personal experience in dealing with the business inventory exemption. And then we'll go into what we believe is the law, the governing rules in this case. And then that's basically our presentation. So with that, what I will do is ask that each of these exhibits be introduced as I go through my presentation. So with that, I'd like to, we're here today to convince you that the sale of the aircraft in question was in fact done in such a way and in such a manner that it qualifies for the business inventory exemption. So my first several exhibits strictly just deal with presenting certain facts having to do with what occurred in that process.
Let me just interject real quickly in terms of introducing the exhibits. I see that they're all numerically labeled, so it's like we have 30, but they'll be entered as labeled numerically by the applicant, so we don't have to keep doing it over and over. So, go ahead.
Okay, so I'll just refer to each exhibit number as I go through my presentation. Very good. So the first fact that we'd like to establish is that the owner of this aircraft decided to sell it. So I refer to Exhibit 1, which is a copy of the action of the Board of Directors of Garthorpe Inc., who is the owner of the aircraft. So in this resolution, they're acknowledging a decision to sell the aircraft. Okay.
Excuse me, Chairman Stern, can I interject real quickly before? Just so the record's accurately reflected, while there is 30 tabs, items 28, 29, and 30 are all blank. So just so that the board's record is properly reflected, the board has technically only received exhibits 1 through 27.
At this point, we have several other exhibits that we may or may not inject.
I just wanted, because I had to note this on the minutes, I wanted to make sure that we got that corrected for the record. If the exhibits do expand, I will note those additional exhibits in the record. Thank you.
Thank you.
So we have accepted 1 through 27. Go ahead.
Okay, so at Exhibit 2, we present to you an aircraft marketing agreement between Garthorpe Inc. and a firm called Bloomer DeVere Group, Aviva. We refer to it simply as Bloomer DeVere, a fairly well-known aircraft marketing firm, in fact, located right here in Ventura County. This is the agreement that was put in place between the aircraft owner and the broker. It's a fairly straightforward agreement. It provides for the agent. It establishes an agency between the parties, and it provides for the agent to earn a commission. In this particular case, the commission that the agent is going to earn has been reduced from his standard commission to something lower than that based on the source of the referral, and I'll get to that in a few minutes. So it's a very standard aircraft marketing agreement. So we present that as evidence that the aircraft was being marketed. The third exhibit that I would like to discuss with you is an aircraft management agreement. During the term of this consignment, this aircraft, and prior to the term of this consignment, this aircraft was managed by a firm at Camarillo Airport called Sun Air Jets. This document number 3 is the management agreement between that firm and the owner of the aircraft. Again, this is a fairly typical type of a management agreement in that it provides for the various things, the various activities that the management company will do. And I'd like to just point out a few of those. The first part of this is consumed with definitions, but if you go to 3-4, it talks about the provision of management services. It says the manager hereby agrees to manage the aircraft in a cost-effective manner and furnish certain aviation support services in a cost-effective manner. At 3-5, it provides that the manager shall create and present an operating budget. At 3-6, it requires that the aircraft manager present an activity report on a routine basis. At 3-7, it requires that the management company employ the pilots and provide the pilots to the aircraft owner. But again, is very standard. This is all very standard activity in an aircraft management agreement. At 3-8, it provides for the maintenance and inspections of the aircraft. And it says that there will be third-party providers involved. At 3-9, it talks about the maintenance of records and the creation of logbooks and flight logs. And at 3-10, there's a list of additional duties of the manager. I won't go through each one of them. My point is, it's a fairly comprehensive management agreement between the aircraft owner, Garthorpe, and Sun Air Jet Aviation. So that's Exhibit 3. When the owner decided to, and that agreement was put into effect in 2009, I believe. It's dated July 2009. The aircraft was acquired by Garthorpe Inc., I believe, all the way back in 2002. And so prior to the time it was managed by Sun Air, I'm not quite clear who was involved with it, but Sun Air became involved with the aircraft in 2009. In 2010, when the owner of the aircraft decided to sell the aircraft, they basically went to their aircraft manager at Sun Air and said, we're going to sell the airplane, we need to revise our deal as relating to that management agreement. At that time, the parties didn't actually provide that, didn't document the revised deal in writing. They just agreed verbally between them as to how it was going to be. Later, and as a result of a 441D request from the assessor, they asked us about the revisions and what changed at the time that the aircraft was put into the market. And so the parties, being Sun Air Jets and Garthorpe, actually committed their revised agreement to writing. And that's what you see at Exhibit 4. So this document is dated July 3, 2012, but it's in fact discussing the revision of their understanding between the parties as of July or August of 2010. And so it basically, what this document says is the purpose of this memorandum is to document the fact the verbal revisions agreed upon among the parties to that certain aircraft management agreement between Garthorpe and Sun Air Jets dated July 22, 2009, made among and between the parties at the time Garthorpe decided to sell. This document was created by the parties in response to Ventura County Assessor's request for information pursuant to a 441D request dated June the 28th of 2012. So this document was actually prepared for the benefit of the assessor. And it basically says that because of the decision to sell the aircraft, among other things, that we're going to terminate the flight crew on September the 19th of 2010. The aircraft insurance will be limited to ground coverage only. The aircraft otherwise removed by Sun Air from flight status. From here on out, Sun Air was only to be involved with the ongoing required maintenance of the aircraft. It is agreed that Sun Air would take direction from Bloomer DeVere regarding all activity on the aircraft, including aircraft showings, demonstrations, and other aircraft activity. Because Bloomer DeVere's sales offices are physically located at the Sun Air facility, it was further agreed that the aircraft would be hangared there on a per-day rate basis. Previously, Garthorpe had paid hangar rent on a monthly basis, and so when this agreement was implemented, the hangar rent went from so many dollars, I believe it was $10,000 a month, down to a per-day rate basis. As a tenant of Sun Air, Bloomer DeVere and Sun Air held a close and friendly business relationship with Bloomer DeVere. As such, the need for temporary flight crews, aircraft cleaning for showings, and other activities necessary to market the aircraft could all be arranged by Bloomer DeVere through Sun Air in the informal manner that Bloomer DeVere and Sun Air had enjoyed for many years. In October 2010, unfortunately, the aircraft sale became stalled when an engine problem was discovered during the inspection, and unfortunately that inspection required lengthy repair by Rolls-Royce. Once these issues were finally remedied and Sun Air's time commit was further narrowed, the monthly management fee was reduced from $10,300 a month to $3,500 a month. So these are changes that were implemented in the relationship between Sun Air and the aircraft owner at the time they made the decision to sell the aircraft. They weren't documented until 2 years later, but you can see the parties have signed this document. So that's Exhibit 5. That was Exhibit 4. Moving to Exhibit 5, this is a letter that was prepared and written by Vicki Christensen, who is the chief, I believe she's the chief, I think she's the chief operating officer, I'm not sure, of Garthorpe, Inc., that she wrote to the Mr. Dan Goodman on January the 18th of 2011. And this was the cover letter attached to Garthorpe's required filing of Form 577 for that fiscal year. The purpose of this notice is to substantiate the aircraft inventory exemption under California Revenue and Taxation Codes 129 and 219 and the California Board of Equalization Property Tax Rule 133 for our company's aircraft effective January 1, 2011. I've enclosed a package supporting our position. However, I would like to offer a summary of that data. The aircraft was listed for sale under an exclusive brokerage agreement with Bloomer DeVere, a professional aircraft reseller in July 2010. Sales listings, contracts, advertising, flyers, and aircraft inventory listings are enclosed to substantiate that fact. Additionally, non-disclosure agreements for interested potential buyers are enclosed. The aircraft has been under the sole and exclusive control of Bloomer DeVere since that date. After flying its previously scheduled commitments, the aircraft was removed from flight status in September 2010. Flight logs for the 2010 year to substantiate the flight activity of the aircraft's removal from service. On September 12th, the aircraft was relocated to Dallas. As of this date, there's been no flight activity on the aircraft since its delivery to Dallas. The aircraft was under contract to be sold on September the 10th. Ultimately, the sale was not closed, and the aircraft continued to be maintained as inventory. That sales agreement is enclosed. It is our belief that the aircraft qualifies for the exemption under all applicable Board of Equalization rules defining aircraft inventory. So that was the cover letter submitted to the assessor's office with their Form 577 and I believe the actual 577 is attached. So let's look then at Exhibit 6, if we may. And this is a map, and again, I apologize, it's the Xeroxing didn't come out too well. But the purpose of this exhibit is to demonstrate the level of flight activity that this aircraft experienced in the 9 months leading up to September the 5th. So if you turn to the second page, you'll see that there's a very detailed listing there of every takeoff and every landing that occurred with this aircraft. So during that period of time, between January the 20th of 2010 and September the 5th of 2010, this aircraft made 18 trips, constituted with 66 flight segments. It traveled 88,700 statute miles. In our experience, we deal with owners of aircraft. We know that we recognize this to be very typical business usage of an aircraft. 180 hours in 9 months is actually pretty close to the industry standard for this type of an aircraft. Attached to this schedule and to this map are all of the flight logs and all of the Sun Air trip reports that will support the schedule that shows the hours and the time frames and the locations where this aircraft went. So if I may ask you then to turn to Exhibit 7, which is also a map. And so this map and this set of data shows and documents the activity on the aircraft between September the 6th, 2010, and November 14th of 2011, which is the date the aircraft actually sold. So again, you can see on the next page there's a schedule that shows where the aircraft was. So on September the 6th, the aircraft was in Camarillo, and it remained there until September the 12th. And these, I'm looking at the line items on 7-1, if you want to follow along. So on September the 12th, the aircraft flew from Camarillo to Houston. It did so for the purpose of a showing to a prospective buyer. The buyer seemed to like the aircraft, and so on September the 13th, the aircraft flew from Houston to Dallas. The reason the aircraft went to Dallas is because that's where there's a Gulfstream facility for a pre-purchase inspection. You'll note that the aircraft didn't leave Dallas until January the 20th of 2011. The reason it didn't leave until January the 20th of 2011 is because during the inspection of this aircraft, it was discovered, and we'll have testimony to this effect, that one of the right engine of this aircraft failed an inspection having to do with its gearbox. Think of a gearbox a little bit like a transmission in your car, only this gearbox simply drives accessories. It's not a gearbox for the jet turbine fan itself, it's for the accessories. Notwithstanding, it failed the test and the engine had to be removed. The engine itself was shipped to Montreal, Canada, and repaired, returned to Dallas, and was reinstalled on the aircraft in early January, and the aircraft was returned to service on
January 11th.
January 11th, thank you, Vicki. And on January the 20th, the aircraft returned from Dallas to Camarillo. The reason that during that time, the buyer, the prospective buyer, the reason that the aircraft actually went to Dallas and Houston, that buyer lost patience with the repair process, and in early December kind of bailed or backed out. He had actually signed a firm committed contract and put money into escrow and the whole shebang. Their needs were they needed to buy an aircraft in 2011 before the end of the fiscal year for their own federal tax and other reasons, and so they walked on this transaction, and the aircraft came home back to its home base in Camarillo on January the 20th. The aircraft again did not move until June the 2nd. On June the 2nd, the aircraft was flown to Teterboro on behalf of another prospect. That prospect wanted to view the aircraft, and as is usual, the aircraft is taken to where the prospect is, and the prospect was shown the aircraft. So then on June the 3rd, the prospect and his wife took a flight from Teterboro to Teterboro which is typical. The customer wants to fly in the aircraft and show his family the aircraft. And so they took off from Teterboro Airport and landed at Teterboro Airport on the same day. The very next day, the buyer seemed to indicate that he wanted to move forward. So the very next day, the aircraft was flown from Teterboro to Savannah, Georgia. Savannah, Georgia is where Gulfstream aircraft are manufactured. And so this is a very logical place to take an aircraft for an inspection. And so the aircraft flew to Savannah on June the 3rd for the purpose of starting an inspection that this buyer was going to buy the aircraft. Well, as we'll have testimony to the fact that the buyer, his wife persuaded him not to buy this aircraft, and so on June the 10th, the aircraft was actually flown from Savannah back to Camarillo. So now the aircraft is back at Sun Air Jets in Camarillo. Didn't move again until September the 26th of 2011. The aircraft was flown from Camarillo to Long Beach. No surprise, there's a Gulfstream facility at Long Beach. The aircraft was moved there for the benefit of a third potential buyer of this aircraft, and on the 26th. On November the 14th, the mandatory test flight at a Gulfstream facility was conducted from Long Beach to Long Beach, and then on November the 14th, the aircraft was flown from Long Beach to Portland, Oregon, where the aircraft was sold to the buyer. So that's the activity. That's the only flight activity that occurred on this aircraft during the consignment period. And we'll have testimony to this fact, but the flight logs and the flight records that are in this package will indicate to you that none of the Garthorpe personnel were on any of these flights during that period of time. So this aircraft was not used by the owner of the aircraft at any point during the consignment period. The only movements of this aircraft had to do with the marketing of the aircraft. So that's exhibit number 7. Moving to exhibit number 8. This is the first page you're looking at is a list of the ads that Bloomer DeVere placed in an attempt to sell this aircraft, and then behind that are illustrations of most of these of the actual ads. So if you flip through these, you'll see the serial number of the aircraft that we're talking about is serial number 514, and so I've put an indication where you can clearly see that serial number 514 is being advertised. So on January the 24th. It was an internet ad on BrokerNet, which is an internet type advertisement. On January the 27th, Aircraft Sales World is an online ad. On April the 1st, Executive Controller. Executive Controller is probably the premier advertising source for business jets of this class. This is Executive Controller and Business Air Magazine are kind of the two premier spots, if you will, in terms of print ads, that is. So you can see lots of ads at Executive Controller, several online ads, and several Business Air Magazine ads, and they're there for your review. Okay, moving then to exhibit number 9. This is, you'll see there in the upper right-hand corner, this is Alliance Global Risk. This is the insurance carrier that underwrote the insurance on this aircraft, and the exhibits that I present to you show that the aircraft earned what are referred to as layup credits for the periods that it was not operated. And so the very first one there shows a $10,000, $376 credit on 9-2. There's a separate one for $20,958. On 9-3, there's another one for $12,558. So this is just evidence, indication that the aircraft was in fact not in service, and that the insurance company itself agreed that the aircraft was not in service, and they were giving layup credits against the premium which had been paid. So with that, I'd like to move to exhibit number 10, which is the actual contract of sale between Garthorpe Inc. and the ultimate buyer of the aircraft, which was Delta Point Group Limited. So this, I'm just presenting this to you so that you can have it for your reference. You'll see there that this agreement is dated the 14th day of October, 2011. The agreed purchase price was $19,850,000. There was a deposit requirement, a couple of different deposit requirements. There's a pre-purchase inspection requirement at the Long Beach Service Center there in item 3. At going over to 10-2, item number 4 of this contract requires that the aircraft be delivered in airworthy condition, and not only in airworthy condition, but at sufficient airworthy condition to be operated under FAR Part 135, which would be a charter operation. This aircraft had not previously been operated as a charter aircraft. It was strictly flown for the private business of Garthorpe. The buyer wanted to make sure that the maintenance standard, that the aircraft met the maintenance standard to fly the aircraft in charters to the public, which is a considerably higher standard than you have for just private aviation. At 10-3, at the very bottom there, item Q, prior to the closing, the purchasers have a right to perform an acceptance inspection and a flight of no more than 2 hours, which, again, these are very standard provisions. We see them in every aircraft purchase and sale agreement that we see. At 10-5, all the way at the very bottom of the page, says the seller shall have positioned at seller's cost the aircraft at closing location, provided that the closing location is not more than 1,000 nautical miles from the inspection facility. So the inspection facility was in Long Beach. The closing was in Portland. I believe it's like 650 or so nautical miles. So that's where the actual closing occurred. This is a fairly standard agreement signed by both of the parties, as you can see. So that's the document that actually transferred, that was the basis for the transaction. At Exhibit 11, I have a notarized aircraft delivery receipt. It indicates that the aircraft was sold in Portland, Oregon on November the 14th. About halfway down the page, it shows that the total airframe hours was 4,816.8. And if you were to go back to the exhibit with the Exhibit 7 and look at the very final flight log, you'll see that that's precisely the same number that's on the final flight log.
Can you verify which exhibit we're looking at right now?
11. I'm now looking 11-1,
Okay.
which is the delivery receipt.
Thank you.
Again, it's notarized, and very common practice to have the delivery receipt notarized just as proof of evidence that it actually occurred in the state of Oregon. At 11-2, we have the actual bill of sale, which gets filed with the Federal Aviation Administration.
I don't have an 11-2. I have, mine stops at 11-1.
Oh, I'm so sorry.
All right,
I can give her mine.
Okay. Well, unless you have an extra, we can.
Oh, no, I found it. It was
okay.
marked at the top of the page.
I'm sorry.
All right.
I figured it out.
Please bear with it. The preparation of these exhibits is somewhat tedious, and I fully admit my presentation is not perfect. So, at 11-2 is the actual aircraft bill of sale. This is a required document. This is the document that causes the FAA to take Garthorpe's name off the title and put Delta's name on the title. In this case, Delta bought the aircraft through a trust. So what you see there as the purchaser is Wells Fargo Bank, Northwest National Association, not in its individual capacity, but solely as the owner trustee under a trust agreement. So that probably means to me that, I mean, I happen to know this, the Delta folks were not U.S. citizens, and so they bought the aircraft through an owner trust so that it could retain its U.S. registration. So it's, again, a very common practice. So that's the sale of the aircraft. So at this time, I would like to have Mr. Mark Bloomer join us. Brendan, we have two witnesses. Would you like to swear them both, please?
Yes, that'd be appreciated.
If both of you could stand, please.
I'll now place you under oath. Please raise your right arm. When I complete reading your oath, please state I do. You solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you.
Thank you, Brendan. Okay, Mark. Should I move the microphones?
Whatever's easiest for you guys. Move the mic.
sir. Good morning. Thank you for coming.
Good morning.
Just quick instructions, down means you're off. When it's up, you're on. I'll leave you on for now.
Yeah, that's good. Morning, Mark.
Good morning.
Thank you for coming.
Good morning.
This has been a long time coming. Good morning. Mark's the gentleman that sold the aircraft. So I've got a list of questions. I'm just going to go through them and ask you to respond. What is your full name and job title?
Full name is James Mark Bloomer, and I'm the president owner of Bloomer DeVere Group ABA.
And for whom do you work?
For myself.
Yeah.
And DeVere.
And what's the physical location of your office?
It is 855 Aviation Drive in Camarillo, Suite 205.
And is that at the Camarillo Airport?
Correct.
Is it in fact in the offices of Sun Air?
Yes, we are a tenant at Sun Air.
And how long have you been with Bloomer DeVere?
Since we began in 25 years ago.
And what is the primary business of Bloomer DeVere?
We are an aircraft marketing group and an aircraft acquisition group. So we act on behalf of people wanting to have their airplane marketed so they can sell it. And then we act on behalf of people wishing to acquire an airplane because it's something that you don't do very often, and we do it every day.
And what are your personal job duties?
Well, my job duties are, number one, client communication, and then the main person on the phone when an active prospect comes in to tell them about the airplane, answer their questions, coordinate showing the airplane, and getting the airplane, hopefully getting an offer in on the airplane, and then turning it over to legal to proceed from there.
And how large is your firm?
It's small. So we're, at that point in time, we're 4 people, maybe 5.
Okay. And how many clients have you served over your career?
We've completed more than 600 transactions.
Okay. And you say you had 4 employees?
Yes.
And is Bloomer DeVere involved in marketing of aircraft as part of its ordinary course of business?
Yes.
And your firm both buys and sells aircraft, is that correct?
We'll market airplanes?
Yeah.
And we'll help clients acquire airplanes.
Right. You work for buyers and you work for sellers.
Yeah. Right.
Yeah. And so you've answered approximately 500 to 600 sold over the years. Which firms out there represent your principal competition, and where are they located?
Some of the bigger ones that we compete at our level are AvPro out of Maryland, Jack Pruitt & Associates out of Dallas, Leading Edge out of New York. Gosh, there's 4 or 5 others, but they're scattered around the U.S.
So is it fair to say that in California you're just kind of the premier go-to guy?
We like to think that, but there are others that might disagree. So.
Okay. To your knowledge, is the marketing process of your competitors similar in form and process as to the process that you use?
Yes, to my knowledge, and the exhibits you looked at in those magazines, you'll see all of our competitors doing exactly the same thing.
Yeah. Okay, so please describe a typical arrangement and the typical process when you're engaged to market an aircraft.
Well, typically, we're contacted, in this case, by the management company and then introduced to the client. We provide a proposal to provide the marketing services, and the proposal's fairly detailed about the different ways we'll try and market the airplane and what our commission or our success fee would be at the end. And it's a simple proposal. I think it's only a couple of pages long.
Yeah, they've actually seen your listing agreement, so they know exactly what it looks like. Is Bloomer DeVere licensed to perform the service that it performs for its clients?
No, we're not required to have a license, dealer license or anything like that.
Is it typical for businesses among your competitor group to have such a license?
Depends on what they do. Some of our competitors actually buy airplanes, in which case I would assume, I don't know, I haven't seen their books, I would assume they might have a dealer license. But we don't take title, we don't buy airplanes, so that would be the difference of with some of our competitors.
Mark, are you considered an expert?
Yes,
Have you testified as an expert previously?
yes.
Can I
Very good.
interpose an objection, please? An expert at what?
In the business of selling airplanes, of marketing airplanes,
Which? Selling or marketing?
both. Well,
Well, I
Mark,
think the witness has testified they don't buy and sell aircraft.
okay, so are you an expert at marketing aircraft?
Yes.
Thank you. Okay. In the front of this Section 12 exhibit is a slide that looks like this. Mark, I know this is not the specific aircraft. I know this, but it's a similar aircraft. Would you please tell the board just a little bit about the physicality of what this airplane really is about in terms of its size and so forth and so on? I want them to have a feel for what we're talking about.
So this is considered in the category of an ultra-long-range jet. We have small jets, medium jets, large jets, and then when you get out to 6,000 plus miles, ultra-long range, and that would be the category of a Gulfstream 5. It says the ability to go, nonstop out of Camarillo to Paris. That would qualify this ultra-long range. These airplanes typically hold between 13 and 15 passengers. They're owned by individuals and corporations. They fly quite high. They fly at 42,000 feet as opposed to an airliner that flies at 35, 37,000 feet. There's probably, I don't know, G5s, 400 and 450 that, or maybe 400 that were ever built, and then the model changed.
Yeah. Very good. I just wanted them to have a feel for the size. The wingspan is...
It says the wingspan is 93 feet, 96 feet in length, 93 feet. Height is 26. Heavy, 90,500 pounds. Holds a lot of fuel to go
So
that
the
distance.
height is how much?
The height is 26 feet.
So the hangar that this aircraft goes in is a sizable building.
Yes. Yes, quite
Yeah,
large.
you can't fit this in a typical hangar for a Cessna 172.
Oh, no.
Okay, very good. I just wanted the board to have a feel for the physicality of what we're talking about. So now at this point, Mark, I'd like to ask you some questions about this specific transaction, if I may. Was Bloomer DeVere involved in the sale of this tail number 256LK, this Gulfstream 5 that we're talking about?
We're involved in the marketing of the airplane.
And were you personally involved in the marketing of this aircraft?
Yes, I was lead.
The aircraft marketing agreement between Bloomer and Garthorpe ascribes broad general duties to you as agent to consummate a sale. Please describe in your own terms what all duties are covered by this charge to consummate a sale.
First and foremost, marketing and trying to find prospective buyers, qualify them, and hopefully coordinate the visual showings, the demonstration flights, and then hopefully receive an offer from them. And then work with the owner of the airplane on the merits of the offer, whether or not there's going to be a counteroffer, which typically goes back and forth. And then coordinate the airplane going into the pre-purchase inspection, which is a good 30-day process, and we help monitor that, comment on the results of the inspection, what needs to be fixed, what does not need to be fixed, and then coordinate the delivery flight for the airplane. And along the way, of course, really legal comes in and does the actual documentation work of the letter of intent and the purchase agreement.
Very good, thank you. And was this aircraft sold in a typical manner?
Yes.
Okay. During the marketing period, to your knowledge, was there any use of the aircraft by the owner?
Not to my knowledge.
And where was the aircraft hangared during the marketing process?
Sun Air at Camarillo.
And when an owner of an aircraft such as Garthorpe outsources its flight department, is it typical in your experience for the management company to retain possession of the aircraft during the marketing period?
Yes.
During this marketing period, how did the communications between Bloomer, DeVere, and Sun Air jets work. Were you personally informed of, did you personally inform Sunair of planned showings?
Yes,
And you arranged the showings?
yes.
Were you present at all the showings?
I may not have been present at all of them, but someone in my firm would have been present.
So either either yourself or a representative of Bloomer DeVere was present at all the showings?
Right. The only time, Mr. Rice, I think maybe we were not, and I just don't know if our East Coast rep there or not was there, but the Teterboro showing.
Okay, fair enough. What methods were used to advertise this aircraft?
Well, word of mouth is where you begin, networking within the people that are going to most likely have a buyer for the airplane. So it's verbal and networking first, which is what happened in this case, because that first buyer was sourced right off the bat. And then after we do the photography and the specification sheet, and we're ready to go to internet advertising is usually the next quickest thing. And then we look for published dates for the magazine advertising, and you might catch it be 2 weeks out, but then you might be 60 days out. So it's verbal, internet, and print media.
Okay. Once the agreement's in place and Garthorpe has discontinued the use of the aircraft, when and where was the first showing of the aircraft?
So the first showing of the airplane would have been in Houston. That was the potential buyer. And it was flown to Houston for that visual showing.
And from Houston, it went to Dallas. And what happened when the aircraft arrived in Dallas?
So the Houston showing went well, and the prospective buyer wanted to proceed, so we immediately flew to Dallas so as to limit the flight time, and we had a slot. And Gulfstream has a pre-purchase inspection protocol, and so they really control your life from that point on. And if there's a test flight ordered, then factory test pilots do the test flight. The airplane is then inducted into things where they might open up panels, look inside fuel tanks, look inside the gear, etc. One of the things that's a very common procedure on the engines is to do a borescope, which is like a stethoscope, so they can look up inside with a little camera and see if there's any nicks on the blades or corrosion on the burner cans. And then there's this term called a soap sample, which is the gearbox that you referred to. It does have oil in it, and so they're looking for any contamination, and there are little screens. And if they see, and it's not unusual to see metal on the screens, but if you have too much metal, which was described to me about the size of your little fingernail, then you have to look farther. And I don't know if you want to know that, that's what happened here. So,
Yeah, so it failed the soak test.
Failed the soak test.
And so what happened next?
the first indication was we could fix the airplane in Dallas with the engine on. But then Rolls-Royce, that was from a local engine repair place, then we have to have permission from Rolls-Royce. Rolls-Royce said no, send us the engine. So we went from a 3-day, probably $30,000 repair to what ended up being several months and $400,000 repair.
So just for clarification, the engines on this Gulfstream aircraft are made by Rolls-Royce?
That's correct.
And they control the maintenance protocol for the engines?
On something like that, they're technical people. They would have to authorize if you could do a field repair.
So what happened to this prospective buyer as all this was going on?
They stayed very engaged because it was undetermined how quickly we could get the airplane, the engine back. And they stayed engaged, and then, remember, it was in mid-November or early December, they came to us and said they had, for tax purposes, had to make their acquisition in that tax year, and we couldn't guarantee the engine was coming back over the Christmas holidays. And in fact, I guess it didn't come back till January. So we lost that buyer.
And so what happened next?
Well, then we waited for the airplane to be repaired and brought back home, and then we proceeded with the rest of the normal marketing that had not occurred because we'd found this buyer so quickly during the first phase of the verbal marketing. So we started with the internet advertising, followed by the print media advertising.
And do you recall approximately when the next time the aircraft was flown? What happened next, basically?
There was a lot of interaction with potential buyers, some offers, counter offers, and then several months later, and you have to remind me of the time.
June the 2nd.
That sounds about right. There was a potential very qualified buyer that made an offer that was accepted subject to their visual showing out of New York. And the airplane was flown to Teterboro for that gentleman and his wife to view it and to take what we call a local demo flight.
And so they did take a flight there in Teterboro.
Correct.
And what happened next?
The husband, Mr. Roth, we're going to buy the airplane. His wife had looked at it, and he was so confident that he authorized a further expense to take the airplane down to Savannah, Georgia, at the Gulfstream facility and immediately go into an inspection. But during the few days that the airplane was flown down there and before the inspection started, what I was told is Mrs. Roth decided they were not going to buy the airplane, so they did not.
Very good. So once again, the aircraft was returned to Camarillo. Is that correct?
That's correct.
And from your recollection, what was the next opportunity to show the aircraft?
Well, then the cycle starts again. The internet, the advertising on the phone, explaining to people that the airplane's still available for sale. And we were introduced to a group out of Hong Kong as a prospective buyer. And indeed, a deal was struck. Their representatives came into Long Beach to inspect the airplane, and they ultimately acquired the airplane through the owner trust.
So they inspected the aircraft while it was here in Camarillo.
The first visual was in Camarillo, that's correct.
And then the aircraft was moved to from Camarillo to Long Beach, according to the timeline, on September the 26th, on the strength of their signed letter of intent. Is that correct?
Correct.
And so, again, the facility in Long Beach is a Gulfstream facility where a pre-purchase inspection can be done.
That is correct.
Yeah. And was a test flight flown during that process at Long Beach?
I believe they ordered a test flight from the factory. We'd have to refer to specific records,
okay.
But that's
Thank you.
normal.
That's fine. And this prospective buyer, Delta Point, ultimately purchased the aircraft. Is that correct? They were the ultimate buyer?
Correct.
And the paperwork shows the re-registration to Delta Point on November 14th. Is that your recollection?
Sounds correct.
Yeah. And to your knowledge, during this entire process, did any of Garthorpe's owners, executives, or employees fly on this aircraft?
Not to my knowledge.
Say the specific dates.
That would be the date range between September the 6th of 2010 and November 14th of 2011.
Correct.
Very good. Thank you, Mark. I have no more questions for you. So, thank you very much.
Mr. Chairman, I think we would like to cross-examine the witness.
Okay, hold on 1 second, please. Probably is an efficient way to proceed in terms of, rather than waiting till the end of the presentation and bring the witness back, to allow for questions now, unless there's any objection from the board. Okay, so let's go ahead and we'll start with any questions. We generally don't refer to it in our board as a cross-examination, but if the applicant or if the assessor's representatives have questions for the applicant's witness, that's great, and then we'll go to the board questions, and then we can proceed with your presentation. Go ahead.
Okay, yes. I just have a few questions, Mr. Chairman, members of the board. Mr. Bloomer, as I understand, you act on behalf of sellers and buyers. Is that correct?
Correct.
And is it true that you provide marketing and consulting services for people who want to purchase or sell aircraft like the Gulfstream involved in this case?
Correct.
Now, do you buy the aircraft?
No.
Do you sell the aircraft?
No.
So, at any time during the sale of this particular aircraft, did your company take title to the aircraft?
No.
Under the marketing agreement, do you have the right to sell the aircraft?
No.
The owner has to get involved in that?
Correct. I am not a title holder.
Okay. And in this case, the entity that signed the sales agreement was Garthorpe?
I don't have the sales agreement in front of me, but I would assume
That's correct. That's Garthorpe.
And not Bloomer?
that's correct.
Okay. Bloomer did receive a commission, however.
Correct.
Okay. Would it be fair to characterize your services as a brokerage?
I don't know what adjective you'd want to use. We use marketing and acquisition in our agreements, but I think a common term in the industry is brokers.
Now, during the course of your work in marketing this aircraft, were there expenses incurred in relation to the aircraft? I think you mentioned there was a repair from Rolls-Royce.
Any airplane is going to have ongoing inspections, repairs. During the time we're marketing, there'll be calendar inspections, there'll be a variety of things.
Okay. Who paid for those?
That would be between the management company and the owner. It was not Bloomer.
Okay. I have nothing further for the witness, Mr. Chairman.
Okay, great, thank you. Are there any questions from the board for Mr. Bloomer?
Just real quickly, as far as the question regarding the title, do you ever take title to any of the aircraft that you market?
No.
Okay. Mr. Crow, do you have any?
I have no questions.
Okay, thank you very much. Go ahead whenever you're ready.
Okay, very good. At this time, I'd like to call Mr. Brian Council.
While we're doing that, Mr. Chairman, may the previous witness be excused so he can leave? If he
It's
chooses
okay
to
with
do
me,
so.
it's up
It's
to
fine with me.
the
If there's no more
applicant.
questions of Mr. Bloomer, he's
Okay.
free to go. Thank you.
Okay.
I'm not very skilled at this protocol here. I'd like to introduce you to Brian Council. So, very good. Brian, if you would, state for the record, what's your full name and job title?
My name is Brian Council, Counsil. I am the President and Chief Operating Officer of Sun Air Jets.
And what is the physical location of your offices?
855 Aviation Drive in Camarillo.
And that's at the Camarillo Airport?
Yeah, yes, sir. It's right on the taxiway.
And how long have you worked there?
It's soon to be 17 years.
And Brian, if you would, just for the board's benefit, would you share with us your background prior to joining Sun Air Jets?
All right. I went to college in Santa Barbara, UC Santa Barbara, and then law school at UC Davis. Graduated in 95, took the bar, passed the bar. And then I had been an intern at the Franchise Tax Board and the IRS during that period of time, and so I was recruited out of law school to work at Arthur Andersen, one of the large accounting firms, to be a tax attorney and consultant there. I worked there for approximately 4.5 years until early 2000, which is when I started at Sun Air Jets.
Very good. And what is the primary business of Sun Air Jets?
We do a couple of things. Again, we're at the airport, so we have hangars. If you drive up and down the 101, you might see them. They say Sun Air. It's hard to miss if you're looking. So we have hangars there. We hangar aircraft. We provide fuel to resident and transient aircraft. And then also we perform maintenance services and flight operation services for aircraft that we operate.
Very good. So you perform management for owners who choose to use their aircraft privately, as well as some of your managed aircraft are held out to the public for charter. Is that correct?
That's correct, yes. We operate some aircraft that are chartered, and then others that are just for the personal business use of the aircraft owners.
And Brian, if you would, please share with the board, what are your principal job duties as the Chief Operating Officer?
Well, obviously, I oversee the company as a whole and the executive leadership there. But in my history of having been a tax attorney and accountant, one of my primary job functions is to consult with, take care of, and advise the aircraft owners that we operate their aircraft for. Our mechanics do the maintenance, our flight operations do flight operations. My principal involvement has been, over the years, to help manage our aircraft owner clients.
Very good. And are you familiar with the applicant company, Garthorpe?
Yes.
And what is the nature of Sun Air's relationship with Garthorpe?
Again, this airplane was not chartered, so we operated it, we managed it, as we say, to provide maintenance services, aircraft scheduling for flights. We employ the crew. We do the financial bill pay service for the aircraft, and all the we process the invoices for the aircraft.
I'm sorry. In direct response to the gentleman's question about who paid that maintenance bill, do you have specific knowledge? Would Sun Air Jets have paid that directly, or did Garthorpe pay it directly? Or do you recall?
Generally, during the term of our management services, Sun Air Jets would pay invoices on behalf of the aircraft. In regard to, I think, the gentleman's question about the engine repair invoice, I do believe that those monies came through Sun Air Jets, but I don't recall that specifically.
Okay.
It's possible they can get paid directly by the aircraft owner, but I do believe they came through our firm. That is the norm.
Well, that's our best shot. We don't really know right now, but typically.
Yeah, absolutely. Typically, in again preparing for this meeting, now that this information is 5 years old, we went back and examined some of the accounting records for Sun Air Jets, and we saw those large dollar invoices in our records, which leads me to believe that the monies went through our firm.
During the time that Sun Air Jets managed the Garthorpe aircraft, were you directly involved in all aspects of this relationship? In other words, do you have personal knowledge of the facts and circumstances surrounding this case that we're discussing today?
I do so have personal knowledge.
And is there a written agreement that documents this relationship?
Yes, it was referenced as an exhibit previously, July 2009 Aircraft Management Agreement.
Very good. And during the term of the management relationship and prior to the decision by Garthorpe to sell, who employed the pilots and the crew for this aircraft?
Sun Air Jets employed the pilots and the crew for the aircraft.
And since the pilots and crew were employed by Sun Air Jets, did these individuals provide flight crew services only to Garthorpe? In other words, were they exclusive to the Garthorpe aircraft?
They were exclusive to the Garthorpe aircraft. We had never operated a Gulfstream 5 before, so these individuals are employed for this airplane.
And during the term of this management relationship and prior to the decision by Garthorpe to sell the aircraft, was the aircraft insured on Sun Air Jets fleet insurance policy?
No, this particular aircraft was not on our fleet policy. It had had a previous insurance policy of its own.
And was Sun Air Jets involved in the aircraft owner's decision to sell the aircraft?
No, it somewhat came as a surprise to us.
And did Sun Air Jets refer Garthorpe to Bloomer DeVere to act as the sales agent?
Yes, we'd had a previous working relationship with Bloomer. He's in our building. We believe he's very reputable at what he does. So yes, we did make that referral.
Was Sun Air Jets compensated in any way in connection with this referral?
No.
When Garthorpe decided to sell the aircraft, did the written management agreement between Sun Air Jets and Garthorpe change?
No, not at that time.
Did a relationship change occur at some point in time?
But yes, the nature of what we were going to do for that aircraft as of the time that it became actively marketed for sale did change. Our scope had changed. Our duties had changed.
And in what, to what extent, or what was the difference? How did Sunair Jet's role change when that decision came down?
Yeah, well, prior to that time, we were engaged to be an aircraft operator. We were there to conduct flights, prepare flight plans, do airport destination planning, everything that it requires to get an airplane around for the use of the owner. And then when it was decided to be sold, that activity stopped because they weren't going to use it anymore. So our primary duty then became to have the aircraft ready and available for showings. We had to continue with the maintenance that was required, just by calendar or by time. But nevertheless, the primary objective was to get the aircraft sold. So it was to keep it clean, keep the maintenance up to date, and then interact with the brokerage firm, Bloomer DeVere.
So as those changes, those agreements evolved between yourself and the owner, between Sunair Jets and the owner of the aircraft, were those changes in the relationship documented?
Not at that time. However, they were eventually documented in response to the assessor's question for a memorandum of the relationship in 2012.
That memorandum is the memorandum that we presented at Exhibit 4?
I believe that's correct.
Yeah. You personally were not a signatory to this memorandum, but were you personally involved in its development?
Yes, sir.
In your opinion, does it accurately reflect the revised understanding of the parties as of the time Garthorpe decided to sell the aircraft?
Yes, it is. I do.
Please explain to the Appeals Board your understanding of Garthorpe's intention with regard to the implementation of their decision to sell the aircraft.
Right. They had listed the aircraft for sale in August. It completed the scheduled flight activity in early September, and within days of that, the airplane was off to Houston and Dallas for its first concrete deal. And we expected the airplane, we quite frankly expected never to see the airplane again, which is natural. And so we were told of the intent to sell. They documented an agreement with Bloomer. Within days of the last owner's flight being accomplished, it goes to Dallas and Houston, and it was for sale ever since that time until November 2011 when it sold.
And what happened to the pilots and crew?
Yeah, well, consistent with the expectation of having sold the airplane and not having the expectation of using it, the crew was laid off in September within days of having taken the aircraft to Dallas for its sale transaction. So the pilots and the cabin crew, they were all laid off.
Okay. Moving on. Did Sunair Jets, as the aircraft manager, inform Garthorpe of the possibility of avoiding property tax on the subsequent lien date based on the business inventory exemption?
Yes, we did.
As a professional aircraft manager, and given your background as a tax lawyer, how would you characterize your level of familiarity and knowledge with the business inventory exemption?
Well, as an attorney and a tax attorney, I have the ability to find code and read code, but certainly not very familiar with the business inventory exemption just because it doesn't come up all that often. I at the time had found Rule 133 or whatever. It just wasn't typical for Sunair Jets as an aircraft operator to go through this. However, in this case, it was unique because they weren't expecting to use it. That is, the aircraft. They weren't expecting to use the aircraft.
In its capacity as the aircraft manager, did you or other personnel at Sunair Jets suggest to the aircraft owner that they should notify the county tax assessor of their intent to sell the aircraft and their intent to avail themselves of the business inventory exemption in connection with the preparation of Form 577 for the 2011 year?
Yeah, when you think about it, the lien date, January 1st, 2011, within days of that date was when the 577 was filed claiming the exemption. And not only was the claim of an exemption made at that time, there was the letter you made reference to from Miss Christensen with a whole stack of materials for demonstrating for sale status that was filed with the assessor's office, and then also with Todd Court sent us back from the assessor's office. Todd Court, if that's a name familiar to you, it sent back an aircraft questionnaire, business inventory questionnaire in February 2011. So that's all to say. It gives you the indication that the client was aware of the exemption, and within days of the lien date had filed a whole stack of paperwork supporting the exemption.
Mm-hmm. And the letter you're talking about is what we presented as Exhibit 5?
Yes.
As an aviation professional and tax attorney, in your opinion, did the statements made by Ms. Christensen, the author of the letter, and an officer of Garthorpe show intent to both sell the aircraft and to position the sale in such a way as to achieve the business inventory exemption?
Yes.
Objection. Motion to strike. This gentleman has told us he's not an expert in business inventory exemptions. And how does he know what Mrs. Christensen intended or didn't intend? It's speculation as to what her intent may have been.
Her intent is stated in the letter, in the correspondence that she wrote, and Bryan Counsel reviewed the correspondence that she wrote prior to her transmittal.
Okay. Thank you both. The way we generally proceed is to receive the testimony and place the appropriate weight on it in terms of striking something. It's generally not something that we get involved in. However, we do. The board does deliberate and decide what weight to place on all the information it receives. Ms. Porsche, do you have any additional comments just related to the technical request to strike? As a quasi-judicial board, we're generally a little bit more relaxed related to that specific issue.
Mr. Chair, I'd like just to spend a minute reviewing, I believe it's Exhibit 5, which was the Ms. Christensen letter that the witness was referring to in counsel. Based on my review of the letter, I have no further comments to add to the chair's comments.
Okay.
I do have a response, though, to the argument made by Mr. Rice's associate. This is a document, and the document...
Let me just interrupt for 1 second, if I could. What we generally do is proceed through the presentation. If you have questions at the end, it allows the presentation to be made without interruption, and then we'll definitely hear
I appreciate that, Mr. Chairman. We're in the process of arguing an objection. Mm-hmm. Argument was made. I'd like to respond to that.
Okay, go ahead.
Traditional rules of evidence don't...
The response is very simple here. The response is that the document speaks for itself. It's not up to Mr. Counsel to read a document, or Mr. Rice or Mr. Rice's associate, to read an agreement and tell this board what it means or doesn't mean. That's up to you to decide. So the fact that there's an agreement that may express something that may or may not have been drafted by Ms. Christensen or someone else does not make Mr. Counsel an expert on what her thoughts are or what her intent is.
Okay.
We did not indicate that Mr. Counsel was an expert.
So what we will do is listen to the information presented, the questions asked. We'll note the assessor's objection, and then the board will, during its deliberations, place what it feels is the appropriate weight on any information that we receive.
We appreciate that, Chairman Stern. We just want the opportunity to be heard.
Okay.
May I continue?
Yes.
So let me collect my thoughts here briefly. With regard to the letter that's the point of discussion as Exhibit 5, Brian, did you discuss this letter with Vicki personally? And were you involved in discussions with her that led to the drafting of this letter? I mean, you have personal knowledge of how this letter was developed. I guess that's the question I'm asking.
Sir, since 2009, when this relationship began, I was involved in negotiating the aircraft management agreement with the client. I was involved with managing every day of the aircraft since then. I was involved with discussing and counseling them on the process of sale. I spoke directly with Vicki Christensen many times throughout that process. We were speaking with some degree of frequency about having the aircraft be sold and for them not to use the aircraft during this business inventory exemption period. That is the basis upon which I would claim to know Ms. Christensen's intent and desire to satisfy this exemption.
Thank you. As President and Chief Operating Officer of Senator Jets, how many times have you made a suggestion to an aircraft owner that they should pursue a business inventory exemption?
Once. This is very unusual circumstances where an aircraft owner, even during the period of time of sale, will not use the aircraft for their own purposes. It's not uncommon for an aircraft owner during the period of time that it's for sale to continue to use it. It's a business tool. In this case, they were committed to not using the aircraft during this period, and in fact they did not. And so that's what made this business inventory exemption claim possible.
Very good. Earlier, you indicated that you have personal knowledge of Sun Air's business dealings with Garthorpe. Do you have specific personal knowledge of all the flights flown on this aircraft during the period of time it was being marketed between September the 6th of 2010 and November the 14th of 2011?
Yes.
And does the schedule that I reviewed with the board earlier reflect all the flights that were flown on this aircraft in your recollection?
Yes.
And did any, to your personal knowledge, did any of the Garthorpe executives or owners or employees of Garthorpe fly on this aircraft between September the 6th and November of 2010 and November the 14th of 2011?
No, Garthorpe and its people or representatives, Garthorpe did not use the aircraft.
Okay, I want, where's Exhibit 36? Brandon, if I may.
Do you have an additional copy?
Is it one short?
Yeah. Yes. Wait. No. Sorry. Did everyone get one? Okay. Sorry.
We made 6.
Okay, this is received as applicant's Exhibit 36.
Thank you. Brian, during the period of time the aircraft was held for sale, excuse me, let me start over. The period of time the aircraft was held for sale extended approximately 14 months. Since Garthorpe personnel did not travel on this aircraft during the period the aircraft was held for sale, how did they travel?
Senator Jets would not have knowledge of all the ways they traveled because we wouldn't get involved if they went down to LAX and got on United. However, we do know that they chartered a couple of flights through Senator Jets on other aircraft that are in our charter fleet.
And, okay, very good. Based on the sum total of events and circumstances that occurred in 2010, including the revised relationship between Sun Air and Garthorpe, was it explicitly clear to you that Garthorpe intended to sell the aircraft?
Yes.
During the course of the sales period, was it clear to you that Mark Bloomer was in control of the process and in control of aircraft movements?
Yeah, our daily existence changed substantially from conducting flights for the aircraft owner to now answering to Bloomer DeVere and its agents and representatives in their firm to schedule showings, keep the aircraft clean for showings, keep them advised of maintenance that was accomplished. Typically, in order to be able to sell an aircraft to a prospective buyer, they always want to know the current status of maintenance, what's been done, what's coming due. So in order to advise Bloomer DeVere, we would make reports periodically of the status of the aircraft.
Very good, Brian, thank you. I have no further questions of this witness.
Okay,
We
great.
do have some questions in cross-examination, Mr. Chairman.
Okay, so we'll go to the assessor for questions.
Thank you.
Is it possible that we could take a short break before we do that?
Sure. Let's take a recess for 5 minutes, okay?
That's fine. Great, thank you.
Get us back on the record. And it appears we are now back on the record.
Okay, we're back in session. It's 11:41, hearing item 17 on the agenda, and we left off with Mr. Price with some questions on behalf of the assessor for Mr. Counsel.
First of all, Mr. Counsel, do I understand it correctly? You went to UC Davis School of Law?
Yes, sir.
Well, there's something that's got to be great about anybody that goes to UC Davis School of Law, right?
I'm only left to believe that you did as well.
How'd you guess? I have a few questions for you. During the period of time we're talking about, the 2009 through the 2011 period when the aircraft was sold, who was the owner of the aircraft at issue in this hearing?
Garthorpe, Inc.
At any time, by you I mean Sun Air, did Sun Air take title to the airplane?
No, sir.
Did you use it for charter or lease services at all?
No, sir.
Okay. In connection with the business inventory exemption, other than reading the rules and the code sections you mentioned, did you do any further legal research regarding the business inventory exemption?
No. If at all, not much.
Okay. Did you testify, have you ever testified before about the business inventory exemption?
No.
In fact, as I understood it, this particular case was the only time you've ever discussed it with a client. Is that right?
That's correct.
Okay. Did you assist in preparing and filing the 577 statements with the assessor's office for Garthorpe?
I personally did not. Our controller, Dale Jacobs, at Sun Air Jets, did.
Oh, okay. Is Dale still your controller?
No, sir.
Okay. He's retired?
Yeah, actually he is.
Let me ask you to turn, do you have a copy of Exhibit 4 in front of you, which is the document that was prepared for the assessor's consumption? I think it's dated July 3rd.
Okay. Yeah, I'm sorry, I don't see the July 3rd date on. Oh, yeah, sure.
On the
It's right at the top.
Front page, yeah. Okay. Did you draft this memorandum of agreement?
No.
Okay. And who is Stephen Lassiter?
Steve Lassiter was my predecessor, at that time the president of Sun Air Jets.
Okay. And this agreement wasn't prepared and signed until long after the airplane had already been sold, is that right?
I believe it was less than a year after the aircraft was sold, but yes, it was in 2012.
All right. And it was prepared for the assessor's use, is that right?
I believe it was prepared in response to a question from the assessor's office.
Okay. Let's turn to Exhibit 5, if you would. That is the letter from Ms. Christensen that you talked about during your testimony.
Yes, sir.
Did you draft this letter for Ms. Christensen or assist her in drafting it?
Personally, I did not. I believe it was, well, I shouldn't say what I believe. I did not personally draft this letter.
Okay. Did anyone from Sun Air assist her in drafting the letter?
I believe so.
Who would that be?
Dale Jacobs and Steve Lassiter. But I don't have personal knowledge of that.
Okay. I have nothing further,
Okay.
Mr.
Okay,
Chairman.
Thank you. Are there any questions from the board for Mr. Counsel?
On this exhibit number 36, showing that there's accrued expenses for charter. Was this plane ever used for charter to other people?
Let me get a copy of that invoice because I can explain that.
Like on the second
May I
page
respond?
here.
Sure. The invoices that you have as Exhibit 36 were presented as evidence that the owner of the aircraft chartered other aircraft separate and apart from the tail number that was sold. So these charter invoices have nothing to do with the aircraft that we're trying to classify.
Yeah,
This is just evidence that they used other aircraft and not their own.
Okay. Has this plane ever been used as a charter for other people, like a lot of for movie stars as such? I understand a lot of that business comes out from Jet Air.
No, sir. The Garthorpe aircraft was never used as a charter aircraft.
Okay. What is the company do, Garthorpe? What is that? What is that business?
Garthorpe, it's my understanding, the Garthorpe is a name in a movie that was produced by Icon Productions, which is an affiliate of Garthorpe Inc. The folks are in the movie business.
Okay.
Mr. Chairman, I just have one question left for Mr. Counsel.
Go ahead.
Mr. Counsel, during the time that you managed this aircraft and Sun Air received and paid invoices for costs associated with it, did you then bill Garthorpe for all of those expenses?
Yes, sir, and including during the period of time that it was for sale, we reduced our management fee because we weren't doing as much, and again, we reduced our hangar rent to only the days it was there, stuff like that. But yeah, any costs incurred, we would have billed through to Garthorpe.
So ultimately, Garthorpe paid all the costs?
Yeah, I can't afford it.
Thank you.
Mr. Counsel, with respect to the business inventory exemption, you said that that was unique for this one plane. How did that come about? Did you just think of it off the top of your head? Did they bring it up? How was it invoked if it was so unique?
It's unique in this circumstance because the aircraft owner wasn't going to use their aircraft. It could truly be held for inventory. Being a tax attorney, I've been involved with income tax rules and property tax and sales and excise tax, a lot of tax rules. And in that regard, if there's mixed use of the property, it changes the character. But in this case, when you were going to have a singular use and that was for sale and demonstration only, that's where, having had enough exposure, property tax rules and property tax protests on behalf of our clients, that I was aware of the rule and came up with the notion that it would be possible to achieve this exemption in this set of circumstances where the aircraft owner had agreed not to use their aircraft during the for sale period.
Sure. So you were the one that, because of the circumstances, you brought it up to Garthorpe?
Yes, sir.
Okay. So that wouldn't be a typical, if you didn't have the expertise you had, that probably wouldn't have happened with another person in your position.
That's correct. That's one of the value-added services that I feel so good about Sun Air Jets. I mean, in all seriousness, we do things better than other aircraft management companies. This aircraft came to us because we could do it better than the previous aircraft management company. These are the types of service. I don't act as their lawyer. I don't act as their accountant. I don't file their tax returns and all that kind of stuff. But you can be either business smart on how to own an aircraft or not, and the bills can be big. I mean, you know what you're talking about right now is a big issue, and so we endeavor to provide that kind of consultations to our clients, and then engage experts to assist them. Like I said, I don't go through the process all the way from soup to nuts to help them do it. When and if necessary, they engage outside assistance.
Sure. With respect to this exemption, when along this timeline do you think that you had made that conversation with Garthorpe?
Well, in September 2010, when they had entered into a listing agreement and had made their decision to sell and to stop using the aircraft, within days, that airplane, and even prior to aggressive marketing, that airplane was off to Dallas for a prospective buyer. And then the SOAP check, which stands for Spectral Oil Analysis Program, there's no soap involved in case you were curious about that. They test the engine comes off, the test example goes to Louisiana, then Rolls-Royce in Germany says they want the information. They say, no, you guys send the engine to Montreal, and it takes forever and forever and forever for that engine to get fixed. So all of a sudden, through Bloomer's consultations with Senator Jets, it becomes evident that that buyer was getting shaky, that they just weren't going to wait any longer to buy that particular aircraft. The economy was weak. There were plenty of airplanes for sale. They could go get themselves another one. So that deal, unfortunately, fell through. Now you're looking at having an aircraft for sale over the January 1st lien date that you weren't expecting to have for sale at the end of the year. We had fired the pilots. We had cut our management fees. We had cut our hangar rent. We expected never to see the airplane again. Now all of a sudden that airplane's going to still be here on January 1st. And that's when you begin to start to say, oh, by the way, if you're going to own it in 2011 and on the lien date of 1/1/11, you may think about this, but that means you can't use it next year at all. And they go, I understand.
Okay, so again, when was it, right after the SOAP test that you had brought it up to Garthorpe, or January 1? Or
it was
trying to...
the end of 2010 when the sale looked like it wasn't going to happen.
So around Christmas time?
Before the end of the year, yes.
Okay. And again, why is it so unusual that a owner would completely not use it?
Well, because these are productive business assets, and so even during the period of sale, I mean, I have other examples of when the airplane's for sale, but the owner's still using it during the process of sale. And you have to try and fit showings in with, when the airplane's anywhere nearby the home base or anywhere near where the prospective purchaser is. So it's unusual for an aircraft owner to just stop using the airplane. In this case, for reasons personal to the client, they decided that they weren't going to use the airplane. That enables this potential exemption to apply.
Are most of your clients, I'm assuming this plane was owned by one person?
Well, the corporation, yeah.
Corporation,
who owns that corporation, I wouldn't know, because that's not what I would need to know. I just need to know who owns the airplane and who's engaging us, Garthorpe.
Gotcha. Okay. All right, thank you.
I have one quick question. I usually wait until the end to ask my questions because they often are answered, and I don't have to ask as the information comes out. But since you might be leaving, I'm curious about what the test is for, in your opinion, for the exemption. Is it intent not to use, or simply just not using it, or is there a higher test like a contract being executed or a rule that affects the triggering of the exemption?
Sir, in respect to your question, I don't know that I have enough background or research or involvement with the rule to even begin to speculate as to what the rule requires. Like I said, in late 2010, being generally aware of the rule, we advised the client that they could endeavor to satisfy it. But beyond that, sir, I have not made it my life to study this rule since that time. I operate airplanes for a living.
Understood. Thank you.
Chairman Stern, whenever is an appropriate time, if I could ask a question.
Sure. How about right now?
Okay. I've looked at, prior to this hearing, a letter put out by the State Board of Equalization to the county assessors regarding the business inventory exemption. It's letter number 80/69. It's an old letter. It's dated April 25, 1980. And within the context of this letter, there was some question and answer scenario that was run through. And I would welcome from either this witness or from Mr. Rice or from the assessor's representative, at whatever point the parties feel appropriate to address the issue. I just want to flag this issue, and I'm raising it in case it's something the witness can also respond to. But if not, then if the parties could address this. They give an example. It did not deal with aircraft in particular, but I thought there might be some commonalities here. On page 5 in the question and answer portion of the letter, there are question and answers 4 and 5, and I'm just going to read them. 4, do consigned goods that are held for sale qualify for the business inventory exemption? The letter answers yes. Then question 5 is farm or construction equipment that was previously used by a farmer or contractor eligible for the business inventory exemption once it is consigned to an auctioneer for sale? Answer, yes. The equipment is held for sale by the auctioneer whose normal business is selling such goods. And this flags for me that there may be some points that need attention or consideration. I personally don't know whether the auctioneer takes title when they are auctioning an item or not. So that might be something that is relevant to the parties. And the other part of it is the answer talked about whose normal business is selling such goods. So that seems to be also one of the themes that's involved here. And so my question to the witness is, with respect to Mr. Bloom's company that was marketing the airplane for sale, but which did not take title of the sale, what commonalities, if any, do you see between his situation in trying to engineer a sale of the plane and that of an auctioning business that would sell, for instance, a piece of farm equipment that had previously been used by the owner?
I would like to respond to that.
Okay.
And thank you for introducing my exhibit number 17. We're going to talk about it at length when we get there. But specifically, your question dealing with farm machinery. It's typical in the San Joaquin Valley, for example, and perhaps here in Ventura as well, although I'm not that familiar with the Ventura area. But if you drive up and down Highway 99 through the Central Valley, you will see auction yards filled with farm machinery, especially when the economy's down. And so this is a place where farmers bring their equipment, they leave it with the auction yard. The auction yard typically does not take title to this equipment. That equipment is being consigned to that auctioneer when they leave it, and then it's sold. The difference, if you will, between that illustration and what we're dealing with was the reason I had Mr. Bloomer explain to you the physicality of this aircraft. It's 93 feet wide and it's 103 feet long and 28 feet high. You don't take this type of an asset to an auction yard. Where do you take it? You take it to a hangar that's accommodative for that size and style of an aircraft. Where was that hangar? It just happened to be at Sun Air Jets. So in the business of selling, in the ordinary course of selling business aircraft, there aren't auction yards. That just doesn't exist. Farm machinery is consigned and goes to an auction yard and is sold that way. Jets are not. It just doesn't work that way. So that again is one of the unique things about this particular case that we keep referring to in our intro. This is a unique case. This is not going to happen very often.
Can I add something?
Sure, please do.
So you're saying that you can't sell a jet without a hangar?
I wouldn't go that far. I'm just saying that most owners keep their jets indoors. These are very expensive pieces of machinery. They are subject to corrosion. If you have an aircraft, and Mr. Counsel can attest to this, if you have an aircraft whose pedigree is outdoors next to the ocean, that aircraft is going to be worth less in the market than it is if it's been hangared and professionally maintained. So the concept of hangaring an aircraft is an important part of its maintenance program.
Sure, but I'm just saying,
keeping
it in a hangar is one thing, but when, hey, I'm going to sell it and You don't need
No.
to have a hangar to actually.
Not necessarily, no, but when we actually sold the aircraft, it wasn't in a hangar, it was in Long Beach.
Sure.
But the concept, the question here is relating to an auction yard or a place where the equipment goes. I'm just merely trying to explain that doesn't happen in business jets.
Yes.
I just wanted to. Oh, I'm sorry. Did you want to go?
This is Brian speaking. There is no used car lot for airplanes. That is to say, they don't accumulate ones for sale in one common location. They're typically, as you've seen even in this case, they're either flown to a prospective buyer or
The buyer comes to the airplane.
the buyer comes to the airplane. So again, there's no lot. There's no used car lot for airplanes.
If I may add a response to Ms. Porsche, she had stated that question number 4, do consigned goods that are held for sale qualify for the business inventory exemption in that letter to the assessors? And I just wanted to go further into the definition of consignment, if I may. Out of the Consolidated Accessories Corp case, it says a true consignment constitutes an agency or bailment relationship between the consignor and consignee. The consignor, as principal, retains the ownership, may recall the goods, and sets the sales price, whereas the consignee, the agent, receives a commission and not the profits of the sale. And the analogy there with respect to Garthorpe is clearly Garthorpe did not sell the aircraft to Bloomer DeVere. It consigned it to Bloomer DeVere. Bloomer DeVere only accepted commission upon the sale of the aircraft, not actual sale proceeds.
Would it be possible after the hearing to get your...
When we get there,
Absolutely.
this is one of my, we haven't gotten there yet.
If I can respond briefly.
Go ahead.
This really isn't the time to engage in legal argument. Probably that would be at the close of the case when we do summation. But just so you know, if you looked at that letter, you'd also find at item number 17 that Mr. Walton specifically tells you that aircraft are not subject to the business inventory exemption in that same letter.
That's
Now
old
that,
law.
excuse me, please don't interrupt me when I'm speaking. Now that law, that was changed with further changes to the statutes that related to the level and methodology of assessment for aircraft as opposed to other types of personal property. But this, at the time of this letter, aircraft were not eligible for the exemption at all. To speak to your question about consignment, we don't disagree with the concept that if goods are consigned, as they were to an auctioneer, who had the right to sell them, and we've heard Mr. Bloom have said he didn't have that right, and had the right to collect the proceeds, which Mr. Bloomer did not have, then we might have a consignment. But as we'll discuss later, even under the case cited by counsel, consignment is more than just a brokerage. It's more than just an agency. And we don't have a consignment here. And we'll speak to that specifically later.
I look forward to hearing from
It doesn't
everyone.
matter whether it's, 50 tractors in somebody's backyard or one airplane sitting in a hangar. The language in the law doesn't change. We don't have a different law for airplanes that are big from airplanes that are small. It's one law. And as we'll see when we get to the assessor's case, in this case, Garthorpe's plane does not qualify for a business inventory exemption.
Okay.
Thank you, Mr.
So
Chair.
we're in good shape for now, and then I'm sure we'll revisit it. And so are there any other questions for Mr. Counsel from the board, from the assessor? Okay.
Thank you, Brian.
Again, Mr. Chairman, can Mr. Counsel be excused as a witness?
Yes, that's really at his option or the applicant's.
Good.
It's not something that the board generally gets involved with.
We're good.
Thank you.
Thank you.
Thank you.
I'd like to proceed. And Brendan, if I may, I have
sure.
one more, or perhaps several more. But what I'm going to do next is a little bit perhaps unusual, because I fully understand that your decision in this case is your decision, and you have the decisions of other appeals boards have no direct bearing on your decision in this particular case. But I have, because of what I do, I'm an aviation CPA. I see these cases from time to time. As Mr. Counsel testified, not very frequently. The facts and circumstances as it relates to a business aircraft simply don't coincide, so to speak, with the business inventory exemption. But when they do coincide with the business inventory exemption, we believe that the taxpayer is entitled to that exemption. So what I've just handed you as exhibit number 14 is a case that I presented in Orange County having to do with facts that are extremely similar to the facts that are presented in this Garthorpe case. And I'd just like to quickly walk through this with you so that you'll have some, as you deliberate your decision, if you choose to look at this, you'll have some idea of how it was dealt with by the assessor in Orange County back in 2013. So this presentation was made to the Orange County tax assessor after this applicant made their initial filing and so forth. In this particular case, this aircraft that was owned by an entity called KM Aviation was used until November the 15th of 2012, at which time they entered into a binding agreement with a company called West Coast Aircraft Sales, whereby the aircraft would be held for sale. Subsequent to November 15th, all flight activity on the aircraft ceased except for the flight activities necessary to effectuate the sale. On September 10th, 2012, on December 10th, 2012, so we're all the way into December now. December 10th, 2012, an offer to purchase the aircraft was received and negotiations began. On December 17th, 2012, a definitive purchase agreement was signed between KM as seller and J.D. Oliver as the buyer. On December the 20th, an aircraft pre-buy survey agreement was signed among the parties, and the aircraft was flown to the Citation Service Center in San Antonio, Texas. The pre-purchase inspection was completed on or about January 14th, and the aircraft was sold on January 16th to the buyer in San Antonio, Texas. Under the foregoing circumstances, we believe that this aircraft should be exempt from the property tax as business inventory on the lien date of January 1, 2013. Then the letter goes on to state, our basis for why we felt that way and why we believed it, and we provided the Orange County tax assessor with some background information, and then we also attached a fairly significant list of exhibits, which you can see at 14-9, the list of exhibits that we provided to the Orange County assessor. Now, the reason I wanted to share this with you is this. The taxpayer, in this particular case, had a really strong bias. He didn't really want to pay the tax. He was not going to pay the tax. And we advised him that either way, regardless, you've got to pay the tax. There's no, you got to have the right attitude to pay the tax. And he resisted, and he resisted, and he resisted. And finally, on August the 30th, one day before the tax bill went into penalty, he gave me a check. And I walked it into the assessor's office in Orange County and asked for a face-to-face meeting with this individual, Ms. Din. And she came to the counter, and we stood at the counter, very much like your counter here, And I told her why I was there. And I paid the property tax bill, got the receipt, and then I gave her this package. And standing at the counter, she was generous to me in that she allowed me to give it to her, but she was clearly not in any way, shape, or form going to comment about it or have any reaction whatsoever. Well, in Orange County, the appeals filing date is September 15th. And so this happened on August 30th. And so I said, well, it'd be really nice if, if between now and then you have an opportunity to review this package and let us know one way or the other, because if you think you're going to decline, we're going to file an appeals application and go to the board with it because we feel like our facts are good. And so she accepted my package that I gave to her. And on September the 11th, 4 days before the filing deadline, she called me and indicated that she had just forwarded to the Orange County Controller the necessary paperwork to cause the Controller to issue a full refund of the tax that we had paid. So I would, as you deliberate this case, I would ask that you look at the similarities between this case and the Garthorpe file and just understand that in that particular case in Orange County, that the supervisor of their Marine and Aircraft Division accepted the facts and accepted the assertion that the aircraft was eligible for the business inventory exemption.
Okay.
So,
Mr. Vlahakis, that was received as number 14.
Correct. Okay. Mr. Chairman, before you do that, I'd like to, it's not only unusual, it's illegal to present this.
Okay,
the decision.
I just want to stop you for 1 second. I'll ask Ms. Porsche, because we normally receive any information presented, assigning the appropriate weight on it. Ms. Porsche?
Mr. Rice, did you receive the permission of KM Aviation?
I did. They're my client.
Okay, so they gave you the release
Yes.
to present this because
Yes.
it then becomes a public record.
Right.
And
No,
I think if that council was going to address the private, normally private nature of individual tax information, but if you have your
No,
client's
I do.
release-
Mr. Price, go ahead.
Yeah, Mr. Chairman, first of all, everything you've just heard is hearsay. It's all a comment about what somebody said outside of the hearing room. Ms. Dinn is not here to discuss it, nor is she here to discuss their evaluation or what they based their decision on. And unless you want to try the issue of this particular aircraft, K&M Aviation's November 417 Quebec, in this hearing, it's improper to present this. This has absolutely no relevance to the case at hand. This isn't Orange County. This isn't the case involving this good. Here we have a contract, which the board can see if you look at page 10, which is labeled consignment agreement, which we don't have in this case.
Understood.
So start making these comparisons, and utilizing information from another county has no bearing and no relevance to the hearing in this hearing. If we want to do that, let's talk about the Assessment Appeals Board case in L.A., where Mr. Rice's firm lost the case, and the
Let me
appeals
just
board
stop you.
determined that
Let me
it
just
was
stop
not
you for 1
entitled to a
second,
business
please.
inventory exemption.
I just want to deal with this issue right now, and so, Ms. Porsche, unless you tell us that we cannot receive it, then we'll receive it and place the appropriate weight on it as we normally would, noting the assessor's objections.
Yes.
Okay. And are there any questions or comments from the board on this specific issue? Okay.
May I just state that the traditional rules of evidence do not operate in the Assessment Appeals Board, and we all know that, but I think Mr. Price is not aware of that, and he brings court rules into, evidentiary rules into our board hearing, and I just want to make that point.
I think Mr. Price was ably representing his client, and he has a legal right to make the objections that he feels appropriate, and the board will take into account all the objections that either side make in its deliberations and consideration of the exhibits that are proffered.
Yep. Thank you. Okay.
Okay. So, is now an appropriate time for me to undertake to present to you my view of the law?
Yeah, it's up to you how you present all of your information. for the case.
Very good. Then I would like to do that. And I want to walk you through a number of exhibits that we believe are, have relevance to this particular case. And again, some of this, I'm sure you folks are very familiar with most of this material, so I'm going to move through it relatively quickly. But I'd like to, I should do 15, huh?
Yes.
I'd like to direct your attention to Exhibit 15, if I may, which is entitled Consignment Terminology. And I just want to take a very brief moment to make the point that the terminology that's used in law versus the terminology that's used in the available guidance provided to assessors is different. And we've actually written to the Board of Equalization about this and asked them for clarification and so forth. But and we'll quote some case law that would refer to Garthorpe as the consignor and Bloomer as the consignee. And that would be true in the Second District Court of Appeals case that was referred to earlier that we'll talk about in a moment, and it's true in mercantile law. However, in the Assessment Appeals Manual, AH 576...
Mr. Chairman, if Mr. Rice is making his argument about the law, he's certainly entitled to make that argument to the board, but I'd like it to be clear that it's argument, unless he has not factual evidence.
Okay, let's let him present the information and we'll go.
In AH 576...
Do you have a page number in that?
I do.
Okay.
I'm going to present it as an exhibit.
Okay.
I'm laying the foundation for the fact that there are terminology differences, and it's important to understand these differences if we're going to understand some of the opinions that have been issued by the California Board of Equalization. That's my point. So I was trying to lay foundation, if I may, as to this terminology difference. So in the guidance that is available to the assessor, Garthorpe is referred to as an owner, and Bloomer is referred to as the consignor. So it's just kind of backwards from what it is in the law. And I just want to point that out because we're going to present some law, and it's going to be referring to the consignee, and I want everyone to understand that in that context, we're talking about Bloomer. So that's my... So at the bottom of that, Exhibit 15, I've just put in some very brief definitions that I'd like to put into the record. According to Black's Law Dictionary, the definition of consign is to transfer from oneself to the care of another or to send or transmit goods to an agent. I refer back to the agreement between Garthorpe and Bloomer, where it very specifically referred to Mr. Bloomer as an agent. The definition of consignment is the act or process of consigning goods. So I just wanted to make those definitional differences before we move into the actual available guidance that's in California. So if I could, I'd like to refer to Exhibit 16, which is Revenue and Taxation Code 5391 and 5392, basically saying that aircraft which are considered business inventory within the meaning of Section 129 shall be included in the business inventory exemption. That's right in the statute. The next page, California Revenue and Taxation Code Section 129, business inventory shall include goods intended for sale or lease in the ordinary course of business. Business inventory shall not include goods that are actually leased or rented on the lien date. Down at 219, that's kind of ancient history. I don't need to point that out. Moving over to, actually, I'd like to move to the next exhibit, which is 17, which is the letter to the assessor that Ms. Porsche referred to earlier. And again, I would just like to go to 17-5, where it specifies under question number 4 that consigned goods that are held for sale qualify for the business inventory exemption. And the answer is yes. I'm not going to speak to the question asked in number 15 at 17-6 because the law has changed. And I believe that's okay. At so I think that's the relevant part of 17. Let's go to, if we may, to 18. This is another letter to the assessor. Again, it's back in 1980. A large portion of the guidance that is available was developed by the Board of Equalization in 1980 because that's when the significant change in the law occurred, and so a lot of the guidance that's available is somewhat dated. At the bottom there at item 3, it says, by treating general aircraft like other personal property, those held for sale or lease in the normal course of business are eligible for the business inventory exemption. So again, there's guidance going back to 1980 that says that aircraft held for sale in the ordinary course of business are eligible for the exemption. My next exhibit is 80-1 is 19, and that's letter to assessor 80-144, which says that basically the guidelines for the exemption of an aircraft are the same as for other properties. They must be held for sale or lease as of the lien date. I think we established through the evidence that we submitted in our exhibits 1 through 12 or 13 that this aircraft was definitely held for sale on the lien date. At 19-1, there's a paragraph that says there will be occasions when a combination dealer air taxi operator has used an aircraft in his air taxi operations, but on the lien date he is legitimately offering it for sale. In this instance, the aircraft would qualify. So we see, from our perspective, there's really no, this is an air taxi that took it out of the air taxi service and held it for sale on the lien date. We see no difference between that circumstance and our circumstance, where the owner of the aircraft took it out of private business use and then consigned it for sale before the lien date. At Exhibit 20, this is the Assessor's Handbook for General Aircraft. And at 20-2, Chapter 5, it clearly indicates that aircraft are considered inventory. And then it says they're under business inventories at the bottom of 20-2. Virtually all aircraft held as dealer's inventory in California are flown directly from the factory to airports located in California. Having been flown at least once, the aircraft qualify under Section 5305 as general aircraft. I find it a really strange anomaly in California law. If you build an aircraft in California and it hasn't been flown, it's not an aircraft. So that's what that's referring to. The guidelines for the exemption as business inventory are the same as for other properties. To be eligible for the business inventory exemption, the aircraft must be either held for sale or lease in the ordinary course of business on the lien date. That's a recurring theme throughout the guidance. It's got to be held for sale in the ordinary course of business on the lien date. Now, we heard Mr. Bloomer testify that he's held that aircraft and marketed that aircraft in the ordinary course and the usual way and the usual manner in which he markets aircraft. There at the bottom of that page under item 1, it says a dealer who operates an air taxi service. This is kind of a reiteration of what was in the other presentation that I made just before, where it's making reference to a DOT form that really doesn't apply in this case. So this is the guidance here. Item 1, 2, 3, 4. Item 4 says the typical turnover time for a dealer requires to sell an aircraft is 3 months. Item 3 talks about the number of engine hours. I mean, this guidance really is not being, my point is this, this guidance is not really being directed at the trade level or the market level of the aircraft which we're talking about. We believe that, and if you turn to the very last page in this section, this guidance is really directed towards an aircraft that looks more like this. There is no business jet aircraft being manufactured today that's complete. They're completed green, which means that they don't have interiors in them. They don't usually have paint, and that's why they're referred to as green. The primer coat of paint that goes on an aircraft is green, and so they're referred to as green aircraft when they leave the manufacturer. Then the aircraft goes to a completion center. At the completion center, they put in all the ancillary avionics. They put in the seats, the carpeting, the headliners, and all the creature features and the comforts and so forth. That's done at a completion center. So this indication here in this guidance that an aircraft is manufactured, flown to a dealer, and is there for less than 90 days and sold with fewer than 35 hours on it, this guidance simply does not apply. This isn't talking about the type of marketing of an aircraft that we are talking about. So then moving to Exhibit 21. And if I could ask you to please turn to the second piece of paper, which is a letter that I wrote to Mike Harris, who's the principal property appraiser for the Board of Equalization, Specialty Taxes Department. It's a request for guidance. Having conducted our preparation for this hearing back in 2011 or 12, whenever that was, we felt that the guidance was really, it just didn't seem to meet what it was what we needed, and so we wrote to Mr. Harris and asked for guidance. And in this letter, we discussed this whole issue of whether it's consignee or consignor and the variances in the language. I won't bore you by reading the entire letter. I just want to make you aware of it because I want to read to you their response to this letter. So this letter was asking for guidance with regard to the terminology issue. And so back at the very first page at 21, this is an email from Daniel Paul, who's a senior tax counsel with the Board of Equalization, to myself. And it's dated July the 31st. Now, this is the day that we got the phone call from the assessor saying that they had decided that the board didn't have jurisdiction to hear this case. And so this is all happening real time, just moments before that August 6th hearing was supposed to happen. And so based on my July 5th request for guidance, Mr. Paul writes back and says, "This email is in response to your July 5, 2012 letter to Mike Harris. As we discussed, since your assessment appeal in Ventura County is scheduled for August 6th, we do not have time to address the merits of your appeal. Similarly, we do not have adequate time to respond to your July 12th letter." There's two letters there for your review. "However, we address two general points raised by your letter. The first point, in order for a vessel," because we were asking about AH 576, because there's language in 576. "In order for a vessel held under consignment to be eligible for the business inventory exemption, the assessor's handbook at page 39 requires the consignor to be in the business of selling or leasing vessels." Now remember my terminology matrix. The consignor in this vernacular is Bloomer. So what this letter is saying is that Mr. Bloomer has got to be in the business of selling or leasing aircraft. My letter asserted that the consignor is the owner of the property because the terms are reversed in this guidance, and the person holding the property for sale is the consignee. As such, you interpret AH 576 as requiring the owner of the consigned property to be in the business of selling or leasing vessels. However, in the context of AH 576, the term consignor is used to refer to the person or entity that has taken control of the vessel and is holding it for sale, not the owner of the property. Therefore, in order for the vessel to qualify for the business inventory exemption, the person or entity holding the vessel for sale under consignment, whether they are referred to as the consignor or the consignee, must be in the business of selling or leasing vessels. The owner of the property does not have to be in the business of selling or leasing property. And the second point they responded with was generally whether a consignment agreement exists between two parties is a question of fact. It simply doesn't matter what the title of the document is. It's a question of fact. So the fact that our contract between Bloomer and Garthorpe is entitled a listing agreement doesn't prevent the totality of this arrangement from being a consignment. It's whether or not a consignment agreement exists is a question of fact. The mere fact that a written agreement is labeled listing agreement or consignment agreement is not determinative. Rather, the terms of the agreement creating the relationships between the parties with respect to the property will determine what kind of an agreement has been created. Again, the relevant question for business inventory exemption is whether property is held either for sale or lease in the ordinary course of business on the lien date. I think we've established in our fact presentations earlier on that this aircraft was held for sale on the lien date. So we think that this is an important part of our presentation, and we ask you to give it due weight. So, but before I conclude, I want to talk about at exhibit number 22. This is exhibit 22 actually goes into a discussion of business inventories that's for boats that's actually more relevant. So I'd like to discuss this with you. So at 22-3, the heading is business inventories. Then there's a heading that says property held for lease or consignment. Business inventories include property held for lease or consignment by lessors, sublessors, and consignors. Again, consignor in this case would be Bloomer. Exemptions allowed, however, are not based solely on the status of the vessel on the lien date. The assessor should not judge the validity of the business inventory exemption based on that fact alone, but instead on the true intent of the owner. Individual facts such as a vessel's actual use before and after the lien date, the length of the consignment, and the location of the vessel tend to indicate the owner's intent, but are not singularly controlling. For example, a vessel that is put up for consignment just prior to the lien date and then removed from consignment shortly thereafter in an attempt to escape assessment is ineligible for the exemption. To qualify for the business inventory exemption, the owner or lessor must have the intent to actually have the property available for lease or under consignment in accordance with the regular and usual practice and method of business of the lessor or consignor. Again, we believe that this aircraft was held in the regular and usual practices of Bloomer DeVere as a prominent marketer and seller of aircraft throughout the United States. Vessel owners are not required to be in the business of selling or leasing vessels, only that the property is so held. The business inventory exemption is available to owners who have validly put their vessel up for consignment to a consignor. On the other hand, a vessel held and advertised for sale by an owner would be ineligible for exemption unless the owner's normal course of business is selling vessels. The key to qualifying for the business inventory exemption is that the vessel must be held for sale or consignment in the ordinary course of business of the consignor. So we believe that the facts that we presented to you earlier today position this aircraft specifically in that last sentence, that this aircraft was held for sale in the ordinary course of business of the consignor. So I'd like next to turn to exhibit number 23. And this is
Before you start on that, sorry to interrupt. At 12:45, we'll take a break for lunch until probably 1:30, so that's about 10
Very
minutes.
good. I
So
think...
everyone knows where we are.
Okay.
And I'm not trying to rush you, just making a statement.
Okay. I don't know if I'm going to be able to get through
It's
this
up to
by
you.
then or not, but I'll do my best.
Okay.
Okay, at Exhibit 23, I've provided you with a copy of a letter that was written by the Board of Equalization. This was written by Daniel Paul, the same fellow that responded to my letters via his email in the prior exhibit. But this letter was written to a practitioner named Lucero. Mr. David Lucero was a long-term employee of the Board of Equalization, retired from the Board of Equalization, and went into private practice. And he wrote to the board asking for guidance with regard to issues that are consistent and presented in this case. And so I'd like to go through this with you. And there's 3 situations discussed in this letter, and we're only going to deal with situation 1 because the others are not related to our subject matter here. Situation 1. An aircraft owner, so this is a question that was raised in Mr. Lucero's letter to the Board of Equalization, and the Board of Equalization is simply reiterating the question in their letter so that they can then answer it. So the question is, an aircraft owner places an aircraft for sale with a broker in the state of Washington in July of 2009 and signs a listing agreement giving him exclusive rights to sell the aircraft for, say, $16 million. The broker would earn a 2% fee of the gross selling price, will be charged at closing of escrow, and the broker bears all responsibility for advertising and marketing costs. The aircraft is housed in a repair storage facility owned by a third party who is acting on behalf of the owner to keep the aircraft in good maintenance and according to FAA regulations. The repair facility staff is authorized to show and demonstrate the aircraft to all prospective buyers. Logs are kept that show the aircraft has only been flown for demo and maintenance. Between the listing date and the lien date, only 5 hours have been flown for maintenance. Logs are kept by the maintenance facility showing each flight, and none are for personal or business use of the owners. The corporate aviation company that has the listing has advertised in MSTAT, which is an online marketing service, NetJet, which is an online marketing service, and Plane Mover, which is a magazine, I believe. Due to the down market in corporate jets, the aircraft does not sell until July of 2010 for almost $10 million less than the original asking price. So the original asking price was $16 million as above. The intent to sell is evidenced by the many drops in the selling price before the aircraft is sold. So if I can ask you to skip over to 23-2, where Mr. Paul starts his analysis of the law. And he says, the business inventory exemption, the assessor has the duty to prepare assessment roll and to assess all property subject to the general property at its full tax value. The business inventory exemption is set forth in the taxation code at 219 and 129 and property tax rule 123 and so forth. And he goes on down. At the bottom it says section 129 provides that business inventories include goods intended for sale or lease in the ordinary course of business, but do not include any item held for lease which has been or is intended to be used by the lessor prior to or subsequent to the lease. Consigned goods that are held for sale may qualify for the business inventory exemption. Then it says, pursuant to 5391, aircraft may qualify for the business inventory exemption. Aircraft which are considered business inventories within the meaning of 129 shall be included in the inventory exemption. The guidelines for the exemption of aircraft as business inventory are the same as for other properties. That is, to be eligible for the business inventory exemption, the aircraft must either be held for sale or lease in the ordinary course of business on the lien date. And then he makes reference to AH 576 and says that while an aircraft doesn't meet the definition of a vessel, that this guidance could be useful. And it says, and then he quotes directly out of the AH 577, those 2 paragraphs. And then he responds to situation 1 there at the bottom of 23.3. An aircraft owner places an aircraft for sale with a broker in the state of Washington. The aircraft is housed in a repair storage facility owned by a third party who is acting on behalf of the owner to keep the aircraft in good maintenance, according to it. And you ask the following question. Does the listing with an out-of-state broker meet the criteria spelled out as a vendor or lessor of the property in his ordinary course of business when his course of business is to take listings from anywhere in the United States and sell or lease the aircraft? And Mr. Paul says in response to that, as an initial matter, we note that the burden of proof is on the taxpayer to establish that the property for which an exemption is claimed falls specifically within a specific constitutional or statutory exemption. Thus, the burden is on the aircraft owner to establish to the assessor's satisfaction that the aircraft was held for sale or lease in the ordinary course of business on the lien date, and all other requirements of 129 and 133 were met. For consigned aircraft to be eligible for the business inventory exemption, they must be held for sale in the ordinary course of business on the lien date, in accordance with the regular and usual practice and method of business of the consignor. All other requirements of Section 129 and 133 are met. And then it says, in determining whether or not the business claiming the exemption is selling aircraft as part of their ordinary course of business, the business should have, but not limited to, and it lists these items. The above documentation is evidence that a broker is in the business of selling, leasing, or consigning. You stated in your situation that the broker's course of business is to take listings from anywhere in the United States and sell or lease the aircraft. If such is the case, then the broker should be able to prove some, if not all, of the above documentation. Again, this is a fact-specific inquiry, and the assessor should take all evidence into consideration in determining what business the broker is in and whether or not it's holding the aircraft in the ordinary course of business. The fact that the broker is located outside of California should not affect this inquiry. The second question that is asked is, do all of the following conditions have to be met for a vendor to qualify as a vendor doing business in the ordinary course of business? In other words, do we have to have an FAA dealer's license? Do we have to have a California seller's permit? Do we have to have location on the airport? And so forth. And his answer is, as explained in the documentation, as explained above, the documentation listed in AH 577 is evidence that a broker is in the business of selling or consigning aircraft. However, it is not exhaustive and meant only to guide the assessor's determination. There may be other persuasive evidence of the broker's ordinary course of business. The assessor should consider all evidence, not just the above-mentioned documentation, in determining whether or not the taxpayer has met the burden of showing that the property is held for sale in the broker's ordinary course of business. Point out the use of the word broker here interchangeably with consignor. So the fact that Mr. Bloomer answered the question that some people would refer to him as a broker, we're really talking about one and the same in this response. The assessor should consider all evidence, not just the above-mentioned documentation. In our opinion, it is possible that an assessor could find that property is held for sale or lease in the broker's ordinary course of business, even though the broker could not provide all of the above documentation, which is our case. We don't have, Mr. Bloomer doesn't have an FAA dealer's license because he's not required to have one, doesn't need one. The third question was, does the aircraft have to be in the broker/vendor's physical possession, or can it be in the care, custody, and control of a third party who is an agent for the owner or broker? When determining whether a property placed on consignment qualifies for the business inventory exemption, the assessor must ascertain the true intent of the owner. Factors that reflect intent include the property's actual use before and after the lien date, the length of the consignment, and the location of the property. So we've talked about the location of our property. It was held in the hangar. It was moved around to meet the requirements of prospective buyers. As explained in, as explained in the supporting letter to the property tax annotation 2050180, which we're going to talk about in just a moment, the location of the property is one factor to be considered in determining the owner's intent. If the property remains housed with the owner, it is possible that the owner could use the property for purposes not consistent with its sale, rendering it ineligible for the exemption. In this case, the aircraft is located at a storage facility of a third party. Since the third party is acting on behalf of the owner and not as an agent for the consignor, The owner has not given control of the aircraft to the consignor, and there's still a possibility that the aircraft might be used for purposes other than sale or lease. However, you also state that the logs kept by the third party show that only 5 hours have been flown for maintenance and that the aircraft is not flown for personal or business use. While the foregoing facts are consistent with the aircraft being held exclusively for sale by the consignor, it is our opinion that more facts would be necessary to make a determination that the taxpayer has met the burden. For example, copies of the consignment agreement, the agreement between the owner and the third party, would be helpful in determining the parties' rights with regard to the aircraft, all of which we have provided to you in our presentation today. Further, determining the intent of the owner is a subjective inquiry, and there may be other facts not disclosed that could affect the assessor's decision. So we believe that based on the response here from tax counsel at the Board of Equalization, that the facts as we've presented them actually have a high degree of congruence with the position that that Mr. Paul, who's writing for the Board of Equalization, takes in that letter. And finally, at Exhibit 24, this is another letter that was written to Mr. Charles Knudsen.
Before we get to that, I think we'll take a break now.
Very good.
And come back at 1:30.
Very good.
Objection from the board. Okay.
Thank you.
Thank you.
All right. We're back on the record.
Okay, we're back in session. It's 1:33-ish, and we're hearing item 17 on the agenda, Garthorpe Inc., and we're still working with the applicant's presentation, so go ahead whenever you're ready, Mr. Rice.
Thank you very much. So I was just starting to present Exhibit 24, and this is a letter written by James Williams of the Board of Equalization to Charles Knudsen, and it's back in 1996, where he's asking questions about guidance with regard to consignment status of property. And I'd like to direct your attention to page 24-1, item 3, which states that during the consignment period, the vessel remains in the owner's slip, in the owner's boat slip, or on his property. However, the owner does not use the vessel during the consignment period. Does location or physical possession have a bearing on whether the boat is inventory? And the answer is yes, it has a bearing, but that fact alone is not decisive. Clearly, it would be easier for a boat owner to use a boat consigned to his own slip, but that could also be the best place for the consignee to display the boat for sale. So the location of the boat in the owner's possession should provoke the why question, but if the answer reasonably contributes to the likelihood of a resultant sale, then it would indicate a valid intent to sell rather than a use. Again, the critical element is the intent of the owner, and the location of the consigned boat is an indicator of true intent. We think that we've addressed the issue of where this aircraft was stored, and the fact that it was held in a hangar at Sun Air Jets is not relevant to the owner's intent in this case. I'd like to talk about Exhibit 25, just briefly. Exhibit 25 is a letter to the assessor dated 2003, and it's entitled Hierarchy of Property Tax Authorities. And it goes through the hierarchy, and it starts with constitutional law, federal statutes, so forth and so on. And then it gets down to revenue and taxation code, property tax rules. On page 25-2, it talks about local county ordinance and rules of procedure. And then all the way finally over on page 25-4, it talks about letters to assessor and State Board of Equalization legal opinions, and that's where I'd like to direct your attention. And the last sentence of letters to assessor says these letters are, instructional letters are advisory notices to county assessors and not legally binding. But I'd like to point out under State Board of Equalization legal opinions. Legal opinions issued by the board staff are legal rulings of counsel, which means a legal opinion written and signed by the chief counsel or an attorney who is the chief counsel's designee, addressing a specific tax application inquiry from a taxpayer or a taxpayer's representative, a local government or board staff. Annotations published in the Property Taxes Law Guide are primarily summaries of the conclusions reached in selected legal rulings of counsel. While a legal opinion is not law, the courts typically give weight to an agency's interpretation. Among the factors that courts consider in determining weight given to legal opinions are the expertise of the agency in interpreting the statutory scheme, whether the position has been consistently maintained, and are of a long-standing duration. The board has generally been recognized by courts as possessing expertise and specific legislative authority to interpret property taxation, especially when the board's interpretations have been maintained for an extensive period of time. So we draw that to your attention because we think that that suggests that these letters from the Board of Equalization that we previously presented in our presentation should be given their sufficient merit. With that, I'd like to go to Exhibit 26, which is a California Court of Appeals, Second District Court of Appeals case, having nothing really to do with our case, but I'd like to point to a definition in this case and bring it to your attention. So if you would please turn to 25-1, the 26-1. The heading there is Use of Consignment Agreements. And the second paragraph starts, it says, a true consignment constitutes an agency or bailment relationship between the consignor and the consignee. The consignor, as principal, retains the ownership, may recall the goods, and sets the sale price. The consignee, or the agent, receives a commission and not the profits of the sale. It says, if the parties to the transaction intend passage of title, the transaction may be regarded as a contract of sale rather than a bailment. In this context, we believe that the court is using bailment and consignment interchangeably. In determining which event occurred, bailment or contract of sale, the intent of the parties is controlling. So we point to this definition of a consignment as being an agency or bailment relationship. We believe that the exhibit that we provided you with regard to the listing agreement between Garthorpe and Bloomer constitutes an agency or bailment, and that this definition indicates that determining which occurred has to do with the intent of the party, that the intent of the parties is controlling. And we are convinced that Garthorpe had no intention whatsoever of transferring title to that aircraft to Bloomer DeVere. They hired him as an agent, and we believe, based on this definition of consignment, that that's what happened between Garthorpe and Bloomer, is that it was a consignment. So with that, I'm going to skip item 27, which is the vessels manual, because we've already essentially covered that, and move on to okay, I need bear with me one moment. 25, 26, and 27. Oh, 27 is where I'm at. Okay. It can't be 27. Bear with me.
Yeah.
That's not where I want to be, though. I'm looking for the Assessment Appeals Manual.
Yeah. It's 27, right here.
Excuse me. I lost my place. Exhibit 27 is excerpts from the Assessment Appeals Manual. This manual is some almost 200 pages in length, and so I have obviously not provided you with the entirety of that, but I would like to direct your attention to page 27-12. Should be the last page in that exhibit, which is entitled Burden of Proof. We accepted the burden of proof this morning when we started this hearing, and so now I want to talk about the standard of evidence that we must meet in order to have met our burden of proof, and I believe that this is the relevant guidance for that subject. It says, Evidence Code Section 115 defines burden of proof as the obligation of a party to establish by evidence a requisite degree of belief concerning a fact in the mind of the trier of the fact or the court. The party with the burden of proof is required to establish the existence or non-existence of a fact by producing evidence that satisfies a required standard. And the first standard that's listed is the preponderance of the evidence. Unless otherwise provided by law, the required standard of proof in California is proof by a preponderance of the evidence. This standard also generally applies to assessment appeals proceedings. Thus, with respect to the assessor's presumption of correctness and its exceptions, the party with the burden must prove his or her case by a preponderance of the evidence. A preponderance of the evidence is usually defined in terms of probability of truth and as evidence which, when weighed against evidence offered in opposition, has more convincing force and the greater probability of truth. So from our perspective, we don't have to be able to refute any and all issues that the assessor might raise in this hearing. We only have to provide you with sufficient evidence so that you could conclude that we have the preponderance of the evidence in our favor in this case. We do not believe that the clear and convincing evidence standard, which is documented immediately beneath that, applies to this hearing and to our case. And so I wanted to point that out, that we believe that the standard by which you should measure our evidence is the preponderance of the evidence standard as documented here. And with that, are we done?
Yes.
I think that's the end of our initial presentation.
Okay, thank you. So we'll next go to time for questions about the applicant's presentation from the assessor.
Thank you.
And just a quick reminder to both parties, we'll limit these portions to questions rather than statements, so just a reminder to both.
Well, in that case, we can strike 90% of the applicant's testimony so far. Okay, so, Mr. Rice, are you a lawyer?
No.
Have you been to law school?
No.
Okay. How are you compensated for appearing here today?
I have an engagement agreement with Garthorpe that provides for my compensation.
And how is that compensation determined?
It's based on services rendered at standard hourly rates.
Okay, so your work you're doing here today is based on the hourly rates which you charge?
That's correct.
And the same is true for your associate?
That's correct.
Okay, thank you.
It's not relevant. Just for the record, he asked a question. I'm a certified public accountant, and my practice is devoted exclusively to clients that own business aircraft.
And for the record, I am an attorney.
Okay, and for the record, I'll ask to strike both of those statements as non-responsive to any question which I've asked.
Thank you.
Mr. Rice, you presented in your exhibits a number of letters from the individuals at the legal counsel of the State Board?
I did.
Okay. How many of those were voted on by the State Board?
To my knowledge, none.
Okay.
To my knowledge, there's no requirement that they be voted on by the State Board. Their guidance.
Okay, I have nothing further for Mr. Rice.
Okay, so no other questions from the assessor?
Not at this moment,
Okay.
unless something else comes up.
Great. Are there any questions from the board to the applicant? Okay, I don't have any right now. Great, so we'll go next to the assessor's presentation.
Thank you, Mr. Chairman. Would ask you to bear with us. The hearing so far has been conducted without question and answers. It's just statements made by representatives of the taxpayer. So we're going to try to do it a little differently, but I'd like to give you a brief opening statement. We think what's going to happen when we finish with the assessor's evidence is that the evidence is going to show that there is not and never was a business inventory relationship in connection with the Garthorpe aircraft. And therefore, they're not entitled to the business inventory exemption. You'll note, and we'll get to this in more detail during testimony presented, that the key issues are, is the property held by the owner, lessor, or consignor for sale in the ordinary course of business? Well, I think you're going to find that the evidence will show there is absolutely no evidence whatsoever that Garthorpe was in the business of buying and selling aircraft. Contrary to the dealership air taxi comments by Mr. Rice, that was a dealer. Garthorpe is not a dealer. That would be just like you taking down your car and saying, gee, I don't want to pay registration or tax on this anymore, so I think I'll make it exempt by saying I'm going to sell it. Or taking your boat down and say, I'm going to just change it, make it non-taxable, which is contrary to the Constitution, which, as you know from Mr. Rice's presentation, is the premier authority that we have on property tax. There's no showing the property was held for lease. So that's 2 out of the 3. The only one left is consignment. And we think you're going to see when we finish with the evidence is that, contrary to the argument and and terminology wiggling by the taxpayer, the consignor in this case is the principal, just as it says in the law. The principal is Garthorpe. Garthorpe could have obtained a true consignment, for example, with an auctioneer, who then had the right to sell the property and to collect the proceeds of sale and divide those as they may have agreed with the owner of the property. But he didn't do that. What he went out and hired a broker who got paid a commission and was not given any of the incidents of consignment as opposed to brokerage. The evidence will show, as Mr. Bloomer has talked about and as we will point out, that Bloomer never owned the aircraft. They never had the right to sell the aircraft. That's Mr. Bloomer's testimony. All they had the right to do was market it and try to find a buyer or seller. That's not a consignment. And we're going to point out to you where in the law that is supported. Well, if the owner's not involved in the business of buying and selling, and there's no lessor and there's no consignment, there's no basis for the business property exemption to apply. It's just that simple. And to argue that I'm going to twist the words in the statute and I'm going to make the word consignor into consignee because I'd like to do that to get a benefit from my client isn't sufficient to change the law. You can't reinterpret the law and reinterpret words to help yourself and to help your client when the law doesn't support that. we think the evidence has already shown there's no issue of value, so the sole issue here is how do you classify this aircraft? We know that it's an aircraft, so that's the first part of classification. The subclassification issue is it a property at the lien date in question that should be allowed the business property exemption and therefore exempt from tax, or is it not? That's really the sole issue that is presented to the board. So it's really pretty succinct. I'm not going to take your patience aside and read every single piece of evidence that we put in, but I am going to point to parts of it that I think you'll find convincing as you look at it. Lastly, as pointed out by Mr. Rice, and I agree with him, he has the burden of proof, and his client has the burden by a preponderance of the evidence. That means, in simple layman's terms, it's more likely than not that they should be entitled to a classification as a business exemption, and we don't think that's the case here. So I'll save the rest of my argument for later, but we believe that the taxpayer has not met its burden in this case, and you'll see why in a few moments. So we'll call as our first witness Brooke Hill. Ms. Hill, you've already been sworn, have you not?
I was.
Okay, good. So, Ms. Hill, would you state your full name for the record?
Brooke Ashley Hill.
Sorry, I don't think your microphone was on. If you could, button up
Yeah.
means
Is it
that it's on.
It's up.
It's on.
Okay, sorry.
Is that better?
I can hear you.
Okay. My name is Brooke Ashley Hill.
And where do you work, Ms. Hill?
I work for the Ventura County Assessor's Office.
What is your position?
My current position is Chief Appraiser.
And what are the responsibilities and duties that you have as a chief appraiser?
Well, as a Chief Appraiser in the Assessor's Office, I am responsible for managing and overseeing several specialized sections within the office. I oversee the property transfer and exclusion section, the exemption section, the assessment appeals section, and also the public service section. Within those responsibilities, particularly in the appeals unit, we look at all types of property for valuation, classification, exemption purposes to determine if we've done our job correctly the first time, and in some cases we come before this board and talk about those issues. Sometimes we don't. Other responsibilities that I have include reviewing and analyzing California State Revenue and Taxation Code. I look at property tax annotations, legal opinions, and I look at those to ensure that we're doing our duty in the assessor's office to properly implement the law. Upon my review, I then draft policies and procedures to properly implement these and disseminate that information to the staff.
In connection with exemption issue matters, what exactly do you do as chief appraiser?
I oversee the exemption staff, and we actually exempt over $2 billion a year off the roll. And I train the exemption staff. I review their work. I put together policies and procedures relating to exemptions and ensure that the exemptions that are granted are done in accordance with the law.
And prior to being a chief appraiser, what position did you hold, if any, with the Ventura County Assessor's Office?
Prior to my promotion as chief appraiser, I was a supervising appraiser.
And what did you do as a supervising appraiser?
As a supervising appraiser, I supervised a small group of staff in the residential section of the office, and I trained them on proper appraisal and assessment procedures. I reviewed their work, and we valued all types of residential property, including tract, custom, subdivision land, and then 2 to 10 unit residential properties.
And prior to being a supervising appraiser?
Prior to being a supervising appraiser, I was a lead appraiser, an appraiser 3. As a lead appraiser, I valued all types of property, and I was also the lead appraiser over the exemptions unit as the appraiser 3. And in that capacity, I reviewed the work of lower level staff to ensure compliance with exemption laws. I created policies and procedures as a lead appraiser as well, and just ensured that the work was done correctly.
And in that position, did you also appraise commercial properties?
Yes, I appraised commercial properties, retail properties, shopping centers, oil and gas producing properties, active mining properties. Pretty much, if you can think of it, I probably appraised it.
And prior to being a lead appraiser, what position did you hold with the assessor's office?
Prior to my promotion to lead appraiser, I was an appraiser within the office. I held the official titles of appraiser trainee, appraiser 1, and appraiser 2. But basically, I was a staff appraiser, and as an appraiser in the office, I worked in several different crews. I worked in the residential crew, the tract crew, for about a year, valuing residential property, subdivision land. I worked in the custom crew for about a year, valuing primarily high-end custom homes. And then I spent 2 years in the commercial and industrial group, where I valued all types of property that falls within the commercial and industrial realm.
Now, did you have any occasion to work in the appraisal field prior to working with the assessor's office?
I did. Prior to my employment in the assessor's office, I worked for a fee appraiser. I was a real estate appraiser trainee and also their office manager. I worked for PSI Appraisals. And in that office, I did all sorts of things. I basically took the appraisal from start to finish. I conducted research, I did field checks, I prepared the reports, and we valued property there for lending purposes, single-family residential properties and 2 to 4 unit properties.
Did you have any education that might relate to the public administration area?
Yes, I do. I have a Master in Public Administration, which I obtained in 2010 from California State University, Northridge.
Do you hold any certifications that might relate to property tax assessment?
I do. I currently have an Advanced Certified Property Tax Appraiser certificate issued by the California State Board of Equalization. That certificate requires that I maintain continuing education credits on an annual basis.
And do you also hold a certified property tax appraisal certificate?
Right. So I had that certificate, and it's the same certificate number, I guess. That I held from 2006 forward, and then in 2010 it became an Advanced Certified Property Tax Appraiser certificate.
Have you participated in any groups that work on exemptions for property tax purposes?
I have. I am a member of the California Assessor Association Exemption Subcommittee, and or the CAA Exemption Subcommittee. In that capacity, I get together with peers from across the state. We review proposed property tax legislation, we review current legislation, and we determine, particularly for proposals, what the effect would be on the administration of the law. And we make recommendations to the CAA as far as changes that they should recommend, whether they should support the legislation or not. And on occasion, as part of that subcommittee, I've also been asked to help develop proposals and assist in drafting language for exemption law.
Have you taken any courses relating to appraisal and assessment, and in specifically relating to exemptions?
I have. I've taken many courses on appraisal, assessment, and exemptions. Most recently, I took a course on reading revenue and taxation codes. I've taken several courses in exemptions. I've taken a general course on exemptions. I've taken a course specific to disabled veteran exemptions, another course specific to welfare, church, and religious exemptions, among many other courses related to assessment and appraisal.
Do you have a resume which contain a listing of your qualifications?
I do. I think I handed it to you.
Aha. So we'll ask the clerk to mark as the assessors next in order. I don't know what our next exhibit is, if you could tell us.
I believe this would be Exhibit A. Is that all your submissions?
No,
Oh, no.
But I do need to know, because I think we might have debated some exhibits here before this.
Do you have one more copy?
Yes. I'm sorry. I should have given you an extra for yourself.
Chairman Stern, I think we need to clarify this with council. The assessor's representative had questioned what we should label this next exhibit. I was assuming we were going to call it Exhibit A for this hearing, but he did bring up a good point that this...
If there's nothing else that's been marked A, then it makes sense.
would the initial hearing on jurisdiction and those exhibits have an effect on today's?
No.
I think we would start over today. I think
Yeah.
it's-
Okay, that's what I thought as well, but because the question came up.
Hearing, since the court's order will start with.
Okay,
So we'll
that's
call this
Okay.
Assessors Exhibit A.
Okay. Thank you, Mr. Clerk. Mr. Chairman, we request that you admit Assessor's Exhibit A.
Just did.
Okay, thank you. Okay, so there's some law that we have that we think may be applicable to the board's determination, is there not?
There is.
Do you have copies of some exhibits that we can present to them containing the appropriate statutes, regulations, and legal authorities?
Yes. What would you like first?
Why don't we just start with which one? So we're going to ask the clerk to mark as Assessor's Exhibit B our next document. Oh, this is Rule 129, okay. Ms. Hill, could you identify what Assessor's Exhibit B is?
This is Revenue and Taxation Code Section 129 relating to business inventories. And it's basically a definition of business inventory.
And based on your review of materials, what is a business inventory as you would apply it based upon this section?
Well, a business inventory would include any goods that are intended for sale or lease in the ordinary course of business of the owner.
Okay. And what's our next? Do you have rules and three? Okay. Whatever's next. Okay. What is 321? Oh, we'll do that last. We'll ask the clerk to mark as Assessor's Exhibit C a copy of Section 219. So how many do you need? 4 additional?
You're required to hand over 6 copies.
Yeah, there should be enough for
That should-
both of us.
Ms. Hill, could you identify Assessor's Exhibit C for the record, please?
This is Revenue and Taxation Code Section 219, related to business inventories and exemption.
And would it be fair to say that if property qualifies as a business inventory item under Section 129, then it could be exempt from tax under Section 219?
That's correct.
Okay. What's the next that we have? I'll ask the clerk to mark as Assessor's Exhibit D. Our next document, which is labeled Section 5391. Do you have a copy of that?
Yes.
And could you... Yeah. And could you identify what Exhibit D is for the board?
This is Revenue and Taxation Code Section 5391, specifically dealing with the rate of tax, stating that aircraft that are considered business inventory should be included in the inventory exemption.
Okay. What's next? We'll ask the clerk to mark as Assessor's Exhibit E a copy of Property Tax Rule 133 and ask Ms. Hill if she could identify Assessor's Exhibit E for the record.
This is Property Tax Rule 133, the business inventory exemption.
Now, as might pertain to the hearing that we have today, is there a definition in Rule 133 of ordinary course of business?
There is. It's under A1A.
Okay.
And it says the phrase ordinary course of business does not constitute a limitation on the type of property which may be held for sale or lease, but it does require that the property be intended for sale or lease in accordance with the regular and usual practice and method of the business of the vendor or lessor.
Do we have a lessor in this case?
We do not have a lessor.
And who would the vendor be?
That would be Garthorpe.
Do you know whether Garthorpe is involved in its usual business practices in the business of selling or buying aircraft?
Well, I believe the applicant stated they were in the movie business.
Thank you. What do we have next? We'll ask to mark as the assessor's next in order, which is Exhibit F. A copy of Property Tax Rule 313. I think that's enough right there. And while we're doing this, I'll ask if Ms. Hill can identify Assessor's Exhibit F for the record.
Sure. This is Property Tax Rule 313 relating to hearing procedure.
Okay. And I'll ask the clerk to mark as our next in order, which would be Exhibit G, a copy of Property Tax Rule 321, and ask Ms. Hill if you would identify that for the record.
This is Property Tax Rule 321, burden of proof.
Okay. Okay. Do we have one? What do we have next? Property tax annotation. $100. Aha. No, the one that's 100.008.
Is it that one?
Mr. Rice, if it's Price, sorry. If it's practical to submit multiple exhibits together, that might save our clerk some exercise, and if not, then we'll keep going.
We don't have a lot to finish up for the moment.
Okay.
Is this it? Yeah. No, this isn't it. This isn't it. Okay. Do we have copies of that?
I believe so.
Okay. Oh, there we go. Yep. And we'll ask the clerk to mark as Assessor Exhibit H what appears to be a letter from the State Board of Equalization. And while he's doing that, Ms. Hill, could you identify what we have here?
Sure. This is annotation 100.0008, and it's a legal opinion related to aircraft property tax issues.
Okay. Does Assessor's Exhibit H directs it to an issue of business inventory exemption for aircraft?
Yes, I believe on page 3.
Okay. If I could ask you to refer to page 4 of Assessor's Exhibit H, in particular the quoted language in the middle of the page. Is there a portion that tells us what the board should look for as the key to determining whether we have a business inventory exemption or not?
It does. It's the last sentence right before situation 1. It says the key to qualifying for the business inventory exemption is that the vessel must be held for sale, lease, or consignment in the ordinary course of business of the seller, lessor, or consignor.
Do we have a lessor in this case?
We do not.
Who is the seller?
The seller is Garthorpe.
And you've already stated that it's not their business to buy and sell aircraft, correct?
No, it is not.
And who is the consignor in a case where you have property that's being held?
It would be Garthorpe.
Is that because Garthorpe is the principal in this case?
Right, although they didn't consign the property to anybody.
We'll get to that in a little more depth in a minute. Here. going to give this one back to you. We didn't use that. And now do you have the consolidated case? Okay. And so we'll ask the clerk to mark as Assessor's Exhibit I a copy of the Consolidated Accessories case. 3, 6. Thank you. Would you identify, Ms. Hill, what Assessor's Exhibit I is?
This is Consolidated Accessories Corporation versus Franchise Tax Board from 1984.
And does this case deal with the issue of what is or isn't a consignment for tax purposes?
It does for income tax purposes. It identifies specifically what constitutes a consignment agreement.
Okay. Now, have you had the opportunity to review, look at, and utilize all of the exhibits we've just introduced, B through I, in connection with your work for the assessor's office?
Yes, in regards to this case, I reviewed all of the things that have just been cited.
Okay. So let's talk about Exhibit I for just a moment. In connection with Exhibit I, what is, to your knowledge, what is a consignment?
Well, a consignment is where you have two parties, the consignor and consignee. The consignor gives the property over to the consignee, where they can then sell the property on the consignor's behalf or the seller's behalf. They would be able to collect the money for the sale, and they would then remit the proceeds back to the consignor, which in our case it would be Garthorpe, but they didn't actually do it that way.
Okay, well, let's talk about that for just a moment. Did Bloomer have the right to sell the property without Garthorpe's involvement?
No, Bloomer didn't sell the property, nor did they have the right to sell the property.
Did they collect the proceeds?
They did not.
So would a consignment be, to use an example given earlier in the hearing, something like an auction?
Right. The example that was given earlier was a good example of a consignment arrangement where the farm equipment actually was given over to the auctioneer for the purposes of selling on the consignor's behalf, collecting the money, and then sending the money back to the consignor and only retaining their fee for sale.
Now, in this case, let's strike that. In the auction case, the auctioneer has the right to actually sell the property, correct?
Right. That's the distinction that.
Did Bloomer have the right to sell the property?
No.
The auctioneer had the right to collect the proceeds, is that correct?
That's correct.
Did Bloomer have the right to collect the proceeds?
Bloomer did not.
So do you have an opinion as to whether or not the arrangement with Bloomer was a consignment?
There's been no evidence to suggest that the arrangement with Bloomer was a consignment.
Okay. In the Consolidated Accessories case, was there a consignment agreement?
In this case, there was, yes.
Was it labeled consignment agreement?
It was very clearly labeled consignment agreement.
Did it call the principal a consignor?
Yes.
Did it refer to the recipient as the consignee?
It did.
Do we have that in this case?
We do not.
Is there anything in the marketing agreement that Bloomer signed with Garthorpe that uses the word consignment or that suggests a consignment?
No, there's no language in that agreement that would suggest that it's a consignment agreement. They merely had the ability to market the property on Garthorpe's behalf. In fact, I think that's what Mr. Counsel had stated earlier, is they merely marketed it. They never had the right to sell it.
And is there anything in the purchase and sale agreement that suggests that there is a consignment?
There isn't. The purchase agreement was specifically between Garthorpe and I believe the entity was Delta something or another. But there was nothing to suggest that, no.
So Bloomer didn't transfer the property?
They did not.
Then they didn't collect the money?
No.
Okay. Now, in this case, it's fairly clear, is it not, that the property, we'll call it just the aircraft was owned by Garthorpe until it was sold to Delta?
Right.
Okay. And the agreements that we have been presented with would include the marketing and sales agreements, is that right?
Yes, so we received the marketing and sales agreement.
Were you also provided with income tax returns that reflected Garthorpe's ownership?
Yes, we reviewed the tax returns for Garthorpe, and they owned the plane. They also took the depreciation on the plane.
So they got the tax benefit of the ownership?
That's correct.
And the application filed herein, I have a copy of it right here in front of me, which is a part of the record of this proceeding. Who is the applicant?
The applicant is Garthorpe.
Okay. What other documents might you have submitted that establishes Garthorpe's ownership?
The aircraft property statement suggests that they were the ones that reported to us that they owned the plane, and so therefore we taxed them directly as the owner of the property.
Now, we've talked about the taxpayer not being in the business of buying or selling aircraft. Does the taxpayer, or did the taxpayer at any time, to your knowledge, have a permit that would entitle them to buy or sell aircraft or other personal property?
No, I spoke to the Public Disclosure Office with the State Board of Equalization, and they indicated that Garthorpe has at no time held a seller's permit that would allow them to buy or sell aircraft.
Did Bloomer have a permit at the time of the sale of this aircraft?
No, Bloomer did not have a permit at the time of sale either.
So they couldn't legally sell the property in any event, is that correct?
That's correct.
What about, you have any evidence that, well, in fact, we've already covered that. Just for a moment, let's turn to Exhibit 15 of the taxpayer. Do you have that in front of you?
Yes.
Okay. Are they correct that under mercantile law and under case law, the consignor in this case would be Garthorpe?
Right, the consignor would be Garthorpe.
Are you aware of any place in the other two citations, AH 576, or the letter from Daniel Paul, that says that Bloomer is the consignor?
Not to my knowledge, no.
Okay. Let's take a look at what Mr. Paul had to say. He speaks to the AH 566, does he not?
Yes.
And he talks about the fact that consignor is referring to the person or entity that has control of the vessel in this case and is holding it for sale, not the owner of the property?
That is what it says.
Okay. So can we have a consignment where the consignor is not necessarily the owner? For example, in an auction, is the person who receives it?
The auctioneer would be the
Owner?
consignee. They
Eh,
wouldn't be the owner of the property.
And they wouldn't own the property, would
Right.
they? And if they gave it for somebody else, gave it to somebody else to sell,
I'm sorry?
could they give it to somebody else to sell? Could they consign it to someone else?
The auctioneer or the owner?
Or the owner?
They can give it to whomever they like to sell it.
Okay.
Excuse me, could you let me know what exhibit you're looking at in
Yes, I'm
questioning the
looking at
witness?
Exhibit 21.
Thank you very much.
Okay. So in the second paragraph near the bottom, he talks about the fact that that for that to apply, the person or entity holding the vessel must be under a consignment agreement, right? No matter what they're referred to as.
Right.
But is there a consignment agreement in this case?
No, there's no consignment agreement in this case.
Now, one of the things introduced, which I objected to, let me find it very quickly here. Let me ask you to look at Exhibit 14 for just a moment. And at the very end of that exhibit, this is the improper but utilized Orange County correspondence. Is there a copy of the aircraft sales agreement?
There is. It specifically says it's an aircraft sales consignment agreement.
Do our agreements say aircraft sales consignment agreement?
No, it's a marketing agreement.
So in this case, one of the things Orange County had to look at was the fact they had an agreement that was specifically designated to be a consignment agreement. Is that correct?
Right. It appears as though the circumstances were entirely different.
But there have been other cases, haven't there, where this same issue has already been litigated?
There was a case that Mr. Rice presented in LA County.
Let's see if we can find that case, since we're going to go a little bit afield from Ventura. Do you have copies?
I do.
What are we on, J?
Yes, correct.
Okay. I'll mark as Assessor's Exhibit J a decision of the Assessment Appeals Board, County of Los Angeles. And ask if the clerk would mark that Exhibit J. And would you identify this for us, Ms. Hill?
Sure. This these are the findings of fact for Assessment Appeals Board number 4, application 2006-000314, in regards to the application of Aspen One LLC.
Okay, and in this case, we were dealing with a business inventory exemption, were we not, for an aircraft?
That's correct.
Mr. Lucero appeared as agent.
Yes.
Okay. Could you tell us, does the board indicate what its finding is in this case?
It does. It says that the board finds that Aspen One LLC, the owner is not in the aircraft business, whether by consignment, no title passing, or listing with AVPRO, Inc., an aircraft broker-dealer, is not entitled to an inventory exemption. The applicant's agent is confusing an agency relationship in order to make a case for an inventory exemption, which is not appropriate or applicable. And that's found in the middle of page 4.
So as far as we know, the only board that has considered this has determined that the business inventory exemption didn't apply to the aircraft involved in that case.
To my knowledge, that's correct.
Mr. Chairman, could we have the board admit Assessors Exhibits B through J?
Yes, as they have been submitted, they have been accepted as labeled.
Okay. So, why do you feel that the business inventory exemption does not apply to Garthorpe in this case?
Well, in this case, Garthorpe would either have to be the vendor, lessor, or consignor of the property, and they are not any one of those things. Therefore, the business inventory exemption can't apply.
And in any case, Garthorpe is not involved in the business of buying and selling aircraft, is it?
That's right. In order for the business inventory exemption to apply, they would have to be in the regular course of business buying and selling aircraft. I think they've very clearly stated that that's not the case. It simply doesn't apply.
And our agent in this case, Mr. Bloomer, was very candid. Does his company buy and sell aircraft?
No, they do not.
Okay. So would it be in their ordinary course of business to buy and sell aircraft?
No, I think he clearly stated that they market aircraft and
they weren't even licensed to sell this aircraft at the time it got sold. Is that right?
That is correct.
Okay. So what is your opinion as to whether or not this aircraft should be classified as business inventory?
There's been no evidence to suggest that this should be classified as business inventory. It doesn't meet the threshold under the law as the owner being in the regular course of business of buying and selling aircraft. There is no consignment agreement, and it doesn't meet the threshold for the business inventory exemption to apply.
Do you know of anything that would have prevented them from creating a true consignment?
I suppose they could have, but they didn't.
So the fact that they didn't means the aircraft cannot be classified as business inventory. Is that not correct?
Exactly.
Give us just a moment, Mr. Chairman.
Okay. So, Ms. Hill, will you not be providing any more testimony?
Well, she may be, depending upon what the questions are from the board and from the taxpayer.
Right, that's what I was getting to in terms of questions. So why don't we proceed the same way we did with the applicant's presentation, and if the applicant has any questions of Ms. Hill, now would be a good time.
Thank you. Ms. Hill, are you a CPA?
No, I'm not.
Are you a lawyer?
I'm not.
Have you ever been to law school?
No.
Do you have any background in the Marine and Aircraft Division of the Assessor's Office?
In the Assessment Appeals Unit, we value all types of property, including aircraft and marine property.
But isn't there a separate section called the Marine and Aircraft Division where these items are dealt with? Have you ever been involved in that section?
I don't think there's a section specifically called marine and aircraft property. We have a personal property section.
You said that you've taken a lot of courses and you have all these certificates and so forth and so on. Did any of the courses that you took relate to the business inventory exemption?
You know, the business inventory exemption is something that has come up in many of the conferences that I've attended with my peers from across the state. I'm a member of the Organization of Chief Appraisers. I go to both the business chief and the real property chief appraisal meetings. I believe, in fact, in our last meeting, we spoke of this very issue and discussed it at great length.
Have you ever been asked to analyze a business inventory exemption case before?
Yes, in my work in the appeals unit, this comes up a lot.
Business inventory exemptions on aircraft? Comes up a lot?
No,
I don't think that was the question that was asked.
May I rephrase?
If you work with business inventory exemptions, I think your answer was to that question.
Have you ever been asked to analyze a business inventory exemption related to an aircraft?
I analyzed Garthorpe.
Other than Garthorpe? So this is your first time?
I've analyzed many business inventory exemptions.
I made the point. So would you consider yourself to be an expert in the area of business inventory exemptions as it relates to aircraft?
I would consider myself an expert in business inventory exemptions and assessment.
I made the point. Would you consider yourself, so basically I'm getting the impression that your training is basically on the job training, is that correct? I mean, your degree doesn't have anything to do with business inventory exemptions. So
my degree has a lot to do with how to analyze legislation and implement it, and the coursework I've taken does the same.
I have one final question. So you've expressed an opinion, it's your opinion only, that a consignment has not is not in place in the Garthorpe case, and you expressed an opinion that Garthorpe isn't in the business of selling aircraft, and so therefore can't access the business inventory exemption. So my question is in giving that opinion, would you consider yourself to be a higher authority than the tax council folks that we're communicating with at the Board of Equalization?
In that I've seen all of the evidence surrounding the business inventory exemption for Garthorpe, it is my opinion as an employee of the assessor's office that I am entitled to make on behalf of the assessor that no, the business inventory exemption does not apply.
So if you had written to Mr. Daniel Paul and asked for a response, and he gave the response that he gave to me in my exhibit number 21, would that have changed your opinion? Do you? I guess the question is, you consider yourself a higher level of authority than the Board of Equalization in Sacramento?
I think the question's irrelevant, Mr. Chairman. It's not up to her to determine whether she's a higher level authority or not. Furthermore, the letter given by Mr. Paul doesn't say what Mr. Rice suggests it does.
I think it's understood from the questions and the answers given what the applicant's point was and what the assessor's response was.
Thank you very much. We have no further questions.
Okay. Any questions for Ms. Hill from the board?
In the case of the Los Angeles deal there, one of the comments there on the backside is that the assessors introduced evidence that the parent company had depreciated this aircraft. Has your company been depreciating, or did GoPro depreciate the airplane?
With your permission, when we have an opportunity to redirect, so to speak, we will discuss the depreciation issue.
Okay. Do you happen to know about that issue?
Yes, I reviewed their tax returns that they provided. I do have copies if you're interested. And
I should interrupt to say we didn't put those into the record because it's the taxpayers' tax returns, and we didn't want to put those into the public record, but we can do that if Mr. Rice would like us to.
I think Mr.
I mean,
Crowe just
we're happy to provide them. I
think if you can answer the question, that's fine, and then we can take it from there if there's something that you'd like to present.
Okay.
So to answer your question, Garthorpe did depreciate and get the tax benefit of the airplane.
Thank you. Okay, any other questions from the board? I don't have any questions right now.
All right, I had a quick question. Ms. Hill, as far as the business business exemption, is it a recent exemption, or has it been around for 100 years, or?
Well, I think it's changed over time. At one point, there was no business inventory exemption. Then I think they went to a 50% exemption, and I'd have to look at the R&T code section that applies, but
just roughly. So it's not a recent.
The current section was enacted in 1980.
1980. Okay.
Yes.
Okay.
Prior to that, it was, as Ms. Hill said, it went from 0 to 50% to 75% and eventually to 100%.
Okay. So, kind of to boil it down, with respect to the LA County Appeals Board, on the back it says, applicant was not in the business of buying and selling aircraft in the ordinary course of their business activity, therefore an inventory exemption is not permissible. Would you say that's more or less the crux of your?
Right. Garthorpe was not in the business of buying and selling aircraft. They couldn't possibly qualify for the exemption.
Okay. But if they were, they could.
Possibly. If they were an aircraft dealer, they were licensed to sell it, they met all of those qualifications.
Okay. Okay. I have nothing.
Okay. Go ahead if you have more.
Yeah, just give me 1 second, Mr. Chairman, so we can respond.
Okay.
Okay, we have nothing further at the moment, Mr. Chairman, from Ms. Hill.
Okay, and Ms. Porsche does have one question.
I have a question, and it could be to either council or Ms. Hill, whoever wants to jump in. Going back to that, it's in item 17, the 1980 State Board of Equalization letter to the assessors, 80/69, and the question and answer number 5, that's on page 17-5. The question was, in case of farmer construction equipment that was previously used, is it eligible for the business inventory exception once it's consigned to an auctioneer for sale? Once it's consigned to the auctioneer, who is the consignor in that scenario, in your interpretation of the applicable codes?
The owner of the property, the seller, would consign it to the auctioneer, who would then sell it on behalf of the consignor.
Okay. Because the answer is, so then the auctioneer would be the consignee in your understanding?
And we're going back to the example they used of the farm equipment.
Because the answer says, yes, the equipment is held for sale by the auctioneer whose normal business is selling such goods. So if I'm understanding the way you interpret the answer, the consignee's normal business is selling the goods. It doesn't have to be that the consignor's normal business has to be selling the goods. According to at least how I'm
Yeah,
interpreting
actually,
this, but let me know what your take is.
both the statute and the rule require that the consignor be in the business of buying and selling. Now, as we know from the legislative hierarchy we've been given, the statute and rule would trump any opinion letter from the state board. But in this case, the thing that you need to keep in mind is the auctioneer had the right to hold the property, to sell the property, and to collect the proceeds, and then share those on whatever basis they've agreed with the owner of the property. We don't have that here. In this case, there was nobody who had the right to sell the property other than Garthorpe. There was nobody that had the right to collect the proceeds other than Garthorpe. So we don't have the issue of where there's even been a consignment. And so that is the difference. While in this case, they're talking about what may happen in an auction with a dealer that buys and sells in the ordinary course of business, we don't have that here. And keep in mind, this letter was written in 1980, shortly after the statute was enacted, and is kind of a immediate reaction to what their view was at that time. We're now in 2016, 36 years later, and there's been a lot of water under the bridge during that time period. Yet nonetheless, if you read the actual rule or you read the statute, it says that the consignor, lessor, or owner has to be in the business of buying or selling aircraft. And they're not. They're not. So it doesn't mean that an owner might not give the right to consign his property to someone else, but we have no evidence that that's occurred in this case.
Okay. Any other questions, Ms. Porter? No. Okay, any other board questions? Okay, Mr. Price, if you have more information, we're ready for it.
Well, I have closing argument to provide,
Okay.
but
so
that would be Mr. Rice's opportunity to go first. I don't want to step on.
Okay, so then let's go to...
Actually, Mr. Chairman, the party with the burden of proof goes last, so the assessor's representative would make their closing arguments now.
Oh, I understand, but we are not to that point yet. We're now at the point where the applicant can ask questions of the assessor based on their presentation.
Are we allowed to?
Although the presentation, I mean, was based mostly on testimony by the one expert witness, but I want to make sure that if there are any other questions, we get those taken care of now, and maybe there aren't.
There are, and I have two in deference to time. You folks have been exceedingly patient with us, and we appreciate it. In deference to time, I want to address this consignor consignee terminology issue that Ms. Porsche raised, and then I also want to talk about the question was raised about depreciation in the tax return, and I would like to talk to you about that. I have some exhibits in that regard.
Okay. So let's see. You don't have any other questions based on
I have
the
no
presentation?
further questions based on that
But you do have additional testimony with more exhibits?
I do. He raised issues that I need to respond to.
Okay. So we can accept those. Ms. Porsche, help me if you hear of anything that we're not doing right. If we have additional,
then we'd have to allow
then we
Mr.
go through the
Price
same
an
process.
opportunity for rebuttal or
Right. So would ask that
redirect or whatever.
any remaining testimony or exhibits that you have that you please present now.
Very good. Thank you. I just want to redirect your attention to my exhibit number 21, which fairly clearly states, in the opinion of Mr. Daniel Paul, who's a lawyer in the Board of Equalization, writing on this subject, in the middle of this paragraph says, however, in the context of AH 576, the term consignor is used to refer to the person or entity that has taken control of the vessel and is holding it for sale, not the owner of the property. So in this case, in AH 576, they're using the term consignor to refer to Mr. Bloomer. So that's contrary to what the assessor representative had asserted, and I just want to point that out. Secondly, he made a point that the assignment agreement, or that the marketing agreement between Garthorpe and Bloomer does not say that it's a consignment agreement. And I want to point to the second general statement that Mr. Daniel Paul makes, which says whether a consignment agreement exists between two parties is a question of fact. The mere fact that a written agreement is labeled as a listing agreement or a consignment agreement is not determinative. So I take that to mean that even if it was labeled a consignment agreement, if a true consignment had not existed between the parties, the labeling of it as such wouldn't cause it to be such. Our argument is that it wasn't labeled as a consignment agreement, but in fact, that if you look at the underlying agreements between the parties, their intentions and their actions, it in fact was a consignment. Lastly, the point about whether or not the aircraft is sold at an auction yard where the auctioneer collects the proceeds and then gives the money back to the owner of the property. In this case, and at this trade level, aircraft in the range of $20 million sales price, the money doesn't move anywhere through anybody except through an escrow agent. All of these aircraft transactions are handled by title insurance companies that are located in Oklahoma City because they're in proximate location to the FAA's registration departments. And so all monies goes to the escrow in Oklahoma City and is dispersed from the escrow in Oklahoma City. And you will note in Mr. Bloomer's marketing agreement that his commission was to be directly sent to him from the escrow. He wasn't paid by Garthorpe. He was paid from the proceeds from the escrow, which in my view is very, very similar to this auction situation that the assessor's representative keeps referring to, where the money comes from the buyer to the auctioneer. The auctioneer keeps his bit and gives the rest back to the owner. That's in essence what happened in our example as well. That said, my colleague has a comment.
They made a big deal about Bloomer not having a dealer's license, but you only need a dealer's license if you're actually taking title to the aircraft. And in Consolidated, it said the true consignments do not pass title to the consignee. Consignee only takes its commission, does not actually make the profits of that sale. And I wanted to point out that there are many companies like Bloomer DeVere, like Messenger Jet and Boston Jet Search that don't take title to the aircraft. And the reason why they don't is because they believe it's a conflict of interest, because then when buyers come to buy, they'll be pushing their own inventory because they have an interest to push their own inventory instead of getting the buyer what the best aircraft is most suited for that particular buyer. So I just wanted to make that point.
Okay, thank you. So with that said, we'd like to address the issue of depreciation, if we may. And I have Brandon, what this is. Each clip contains 3 separate exhibits. They're numbers 28 through 30. And I will try to, I keep looking at the clock. I know it's late. I'll try to move through this as quickly as I can. First off, the concept of depreciation is for financial accounting purposes, is like a measurement device, right? It's a concept where you're trying to decide how an asset that's on a balance sheet is going to get moved over into the earnings statement for purposes of measuring income in an enterprise. Quite different from the concept of depreciation in a tax return, in a corporate tax return. In a corporate tax return, the depreciation policies and rules are in place designed to encourage investment in business assets. And so the rules and the reasons why depreciation is there is quite different. Obviously, if an aircraft was owned by a dealer and was held as inventory, that dealer would not depreciate the aircraft. That would be inappropriate because in his financial statements that would be classified as inventory and should not be depreciated. Our facts and circumstances are quite different, and I want to walk through them. So first I'd like to point out that the assessor's representative has provided us with no specific citations or references to the code, to the law, to the rules, to anything that says that depreciation is inconsistent with a consigned aircraft. So I just want to make that clear. AH 577 refers to a dealer who was an aircraft taxi, air taxi operator who then subsequently decides to hold it out. I think it would be very clear in your mind that that person or entity owned the aircraft, was using it as an air taxi. That's a depreciable asset. So at some point during the year, the air taxi operator decides, okay, I'm going to sell this aircraft, and he's bona fide holding it out for sale. He still has to, under the federal tax laws, depreciate that aircraft for the period of the year which it was in service. He has no choice about that. That's in order to prepare a proper tax return, he would have to depreciate it. Internal Revenue Code 168 requires, and this is a subject I know something about. I'm very familiar with this part of the presentation because this is what I do day in and day out as a certified public accountant. Internal Revenue Code 168 requires that the aircraft be depreciated if it's placed in service. This aircraft was in service as a business use aircraft until September the 5th of 2010. So they had no choice but to depreciate the aircraft up to that point.
Was the aircraft depreciated for the period prior to when there was a decision to sell it, or was it also depreciated for the period between September and the January? Or I guess the November date.
I will come to that. To answer your question is yes, it was depreciated in both periods. Okay, so what should have happened is that when the aircraft was held out for sale and deemed to be business inventory, the depreciation should have stopped in that calendar period, and it did not. And I want to walk you through the ramifications of that. I also want to point out, and I'm about to distribute, we did distribute, exhibit number 28, excuse me, and I'll point you to the very bottom of the very first page. These tax returns were prepared by Deloitte Tax LLP, which is one of the premier national, international tax accounting firms in the world, and we'll go through what their comments were with regard to this subject of depreciation in a moment. So with that, I'd like to turn to Exhibit 28, which is now please note at the top of this return that this is for a fiscal year beginning on July 1, 2010 and ending on June 30th of 2011. So this corporation availed itself of the opportunity under the law to have a fiscal year and not a calendar year, fairly common for corporations. And so this tax return covers that 12-month period ended on June 30, 2011, which was prior to the time that the aircraft was sold. You will note that on line 14 of this page, there's a $256,000 number, which is depreciation of some sort. So let me please, if I may, direct your attention to Schedule 28-8, if I may, which is the detailed depreciation schedule in this tax return. You'll note at the very top of this schedule, it says aircraft number 2. The date that it was acquired was March 1st, 2002. Its unadjusted cost or basis is $35 million. You'll note all the way over in the far right column that there's no number on that line. And that's because at the time of this tax return, at the beginning of this taxable year, the aircraft itself was fully depreciated. So this tax return actually contains no depreciation that's directly related to the aircraft itself. However, if you look at the schedule, the same schedule, it lists a June 30, 2004 edition and a June 30, 2007 edition and an August 20 and October of 2009. Those were improvements that were made to the aircraft after its acquisition. Several of those, one of those improvements is in fact a set of spare tires. So the depreciation that's in this return doesn't have anything to do with the aircraft itself. It has to do with improvements that were made subsequent to its acquisition. Nonetheless, there's $256,000 worth of depreciation in this return, and some portion of that should not be there. So I would like to ask you to turn to 28-7, which is a very, I want to go back to the very beginning. On page 1, 28-1, you'll notice on line 19, there's a very large negative expense, $486,969. So one would ask themselves, what is that? So go to 28-6, and you will see on 28-6 there toward the bottom, line 19, other deductions, and it lists a whole bunch of deductions. And then the next to the last one says deduction allowance aircraft entertainment use, and there's a big $1,113,723 negative number there. What is this about? This is about, under the Internal Revenue Code, with the advent of the American Jobs Creation Act in 2005, aircraft owners were no longer allowed to deduct the entertainment use of their aircraft. And so this is Garthorpe's tax preparer's attempt. They've listed all the expenses associated with the use of the aircraft, and here they are backing out $1,113,000 in connection with the entertainment use of that aircraft. So how much, if please turn to 28-7, how much of that $1.1 million that's being disallowed has to do with depreciation? And I do apologize for the size of the font on this schedule. It's very difficult to follow. But this schedule shows that the total expenses incurred for the aircraft, including depreciation for the year, was $1,778,000. And of that amount, 63% was disallowed. So of that $256,000 of depreciation that's on the face of this tax return, line 19 turns right around and takes $161,413 of it out. So what's left in this tax return is what should be in this tax return is the equivalent of 67 days. We take the position that the effective date of the consignment is September the 6th, the day after they stopped using it. So from September the 6th through September the 6th, this return, that equates to 67 days, and so that is 18.4% of the year, and so 18.4% of the $256,000 is $47,000. So what's actually in this return, where the taxpayer is getting benefit, is $47,656, and I derived that by subtracting the $47,142 from the $94,178. The point is, of the $256,000 that's on the face of the return, the taxpayer actually only got benefit for $47,656, which is a fairly de minimis amount and relates to improvements, not to the actual aircraft. If I now may please direct you to exhibit number 29, which is the following year's tax return. So this tax return starts on July the 1st of 2011 and ends on June the 18th of 2012, because that's when Garthorpe Inc. was dissolved as a corporation. So this return has quite a different flavor to it. This return is showing on line 4 net gain on sale of $10,332,000. This return, so what does that relate to? That relates to the gain on the sale of the aircraft, right? So this return also shows depreciation on line 14 of $118,000. So what I submit to you is that the fact that that $118,000 is actually on that line doesn't mean that the taxpayer got benefit for that $118,000, and I'll demonstrate to you why that's not the case. So if I may, let me refer you to page 29-7, which is in Tax Geek Talk is the form 4797, which is where the gain is calculated on the aircraft. And so I can't explain to you why that Deloitte decided to put this transaction into 2 columns. I have no concept of why that was done, but it all relates to the same aircraft. And so I've added the numbers together across, and I've penciled them in column C just to make this conversation a little bit easier. The point of this conversation is this. to calculate the gain or loss on the sale of the aircraft, you start with the adjusted tax basis of the aircraft, which is how much did you pay for it, how much depreciation did you take, what's left. That's the tax basis. You subtract that from the proceeds of the sale, and you get the gain. So if you look at schedule, let me take you back, if I may, to schedule 29-10. So at 29-
Let me interrupt you for 1 second. Sorry. Okay, Mr. Vlahakis, our clerk, let me know that there is a problem with the building ventilation, which is causing everything to smell bad, which we probably have all already figured out, at least the smelling bad part. And Mr. Vlahakis, fill me in if we need more information. You said some offices in the building have voluntarily evacuated. Is that just because
I guess it's stronger in other areas to where they're not able to breathe. So I was informed the clerk of the board's office is all gone right now out of the building. So,
except for you.
Right, I'm down here. So there's no requirement that we leave if it's for some reason making someone sick or making it hard to go on. The chairman could call a recess, although it probably wouldn't be time efficient, but there's no requirement that we stop if everyone is well enough to keep moving forward.
Do we have any reason to believe that there's a health-related issue, or is it more an inconvenience related?
I think it's just an inconvenience, probably some crossed air coming from I don't know where.
From something bad. Okay, so let me go first to our the board members, find out if you have any comments other than the obvious. Okay. And to the assessors' representatives, would you like to keep going?
If we could.
Okay. And
we're good. We're almost done.
Okay, let's keep going.
All right. Thank you. So I'm at 29-10, and in the first column of that schedule are the numbers directly off of the face of the return, including Schedule 4797. What I endeavor to show you here is that if I take that $118,000 worth of depreciation out of this analysis, that the ordinary business income, which is shown on line 21 of this return, would be the same. The reason it would be the same is because the adjusted tax basis would be that much lower, and so the gain would be that much bigger. The income would be the same. So my point is that notwithstanding the fact that there's depreciation in this return on the face of the return, in fact, the taxpayer did not receive any benefit from that depreciation, and that the gain that he recognized on the sale, which was a whopping $10 million compared to the $256,000 that was in the one return and $118 in this return, it's really hard pressed to take the position that the taxpayer benefited from the depreciation in any way, shape, or form. Lastly and finally, I would take you to my Exhibit 30, which oddly enough is an annotation out of the state use tax annotation section. We searched high and low for documentation with regard to this depreciation issue, and this is really the only guidance that we found, and therefore we submit it to you. So this is an annotation having to do with the breeding of horses, which has nothing to do with our case, but we believe that the instruction in the annotation is constructive to our position. So what it was is the person had a horse which he was claiming that he was holding out for sale, and therefore didn't want to pay use tax on owning the horse in the state of California. And the assessor took the position, oh no, it can't be held out for sale because he's depreciating the horse. And so this, I don't know if I know, do we know who wrote this opinion, Vicki?
No, it did not say.
Yeah. Oh, I guess it's, well, it says John B. Ademo, hearing officer, at the bottom of the actual annotation is attached. But the relevant part says this. In this situation, the fact that the horse was depreciated for income tax purposes for several years is inconsistent with the holding of an animal for sale in the regular course of business. If the depreciation had been an error, the taxpayer would generally be required to file amended returns undoing the depreciation. However, a review of the income tax returns for 5 years, a review of the income tax returns for the years the horse was depreciated, disclosed that the purchaser of the horse derived no tax advantage from the depreciation claimed, since the claimed deductions from other sources were more than sufficient to shelter the purchaser's entire income. There was thus no need to file amended returns to undo the tax benefit from the depreciation. The fact that the horse was depreciated, therefore, did not dictate the finding that the horse was not held for sale in the regular course of business. Instead, we look to other applicable facts. We would ask that you do the same in our case. Our taxpayer did have some depreciation in both of those tax returns. The taxpayer received no benefit from either of those depreciation deductions, so we feel that this is guidance that you should take under consideration when considering the fact that on the face of the returns there is in fact depreciation in those returns. What else do you want me to say? I think we're done.
Okay. Any other exhibits to submit?
No, sir, we're done.
Okay. So let's go back to the applicant with any questions related to the additional information. I'm sorry, the assessor.
I have no questions, but I do have some comments on the matters that were raised for the board's attention.
Okay. Are there any questions from the board related to the additional information provided by the applicant? Okay, so probably the best way for us to proceed then is to go to closing summaries, beginning with the assessor, ending with the applicant, and then we will close the
Members of the board, you've heard a lot of information today. Most of it has been from documents and records that were produced or made by other people. So let's talk a little bit about what the issue is here. The issue, very simply, is whether or not to classify this airplane as business inventory, allowing the taxpayer to exempt it and obtain a huge tax break. Now, in the last issues we just talked about, there was an argument, well, yeah, they didn't really get that much advantage. It was only a little advantage. The whole point is that the fact, regardless of what may be applicable for sales and use tax, and for people who are breeding horses and therefore holding them for sale, which has no bearing whatsoever on the case we have here, the point is that, as Mr. Rice commented, if you were an air taxi dealer and depreciating this property and then you decided to sell it, it wouldn't be appropriate for you to continue depreciating it because you are now treating it as inventory, which you don't depreciate. Well, that's the whole point. If this continued to be depreciated, regardless to whether it's $1 or $1 million, the point is it was still being treated and there was still benefit being received by the owner of the property. It was not being held as inventory by the owner of the property, probably because the owner of the property, as the evidence has shown, was not in the business of buying and selling aircraft. And that's the requirement. Now, we've had a reference to Mr. Daniel Paul's little email here. If you would look at Assessor's Exhibit, I'm trying to figure out which one it is. Give me 1 second. H. Okay. And this is a letter from the State Board, right? If you look right here in the reline, what does it say? The first two words, legal opinion. And then there's a long recitation of facts and circumstances which are discussed. And then at the very end it says, well, yeah, that's our opinion, but it's not binding, it's only advisory, which is just above the signature, in this case of Mr. Paul, saying that it's our opinion. Well, unfortunately, their opinion doesn't make law. What makes law is the statutes, regulations, and cases. So let's look at those. Now, the applicant relies wholly upon Mr. Paul's email. Nowhere in his email does he say it's a legal opinion. In fact, if you read the first paragraph in that, this is Applicant's Exhibit 21, it says, we do not have time to address the merits of your appeal. So it's very clear that they didn't consider all the facts and circumstances. This is a hip shot email to help Mr. Rice get his exemption. Then what does he go on to say? And I'm now reading from the end of the second full paragraph. In order for the vessel to qualify for the business inventory exemption, the person or entity holding the vessel for sale under a consignment agreement, which we don't believe exists here, whether they are referred to as consignor or consignee, must be in the business of selling or leasing vessels. That would be, in the applicant's argument, that would be Bloomer. Bloomer has admitted they don't buy and sell aircraft. So clearly, they could not qualify for the exemption, whether you called them consignor, consignee, or whatever other legal term you might want to come up for them. That's in Mr. Paul's letter. The point of the thing, and consignor that he refers to is the person, he says, who has taken control of the vessel and is holding it for sale. Well, that may be his opinion, but that's not what the statute says, and that's not what the regulation says. And unfortunately, Mr. Paul's hip-shot email, which does not constitute a legal opinion and is not offered in that respect, does not trump the statutes and the regulations. The statutes and regulations trump anything Mr. Paul may decide on his own. Let's look at, again, at Exhibit H, and in particular, now this is a legal opinion, certainly more dignity than the hip-shot email of Mr. Paul, and he talks about business inventory.
We've given lots of pictures.
And it says, the key to qualifying for the business inventory exemption, I'm reading from the middle of the page, is that the vessel, keep in mind they're talking about boats, and by the way, the code explicitly says that an aircraft is not considered to be a vessel, must be held for sale, lease, or consignment in the ordinary course of the business, seller, lessor, or consignor. The seller is Garthorpe. Did they hold this in the ordinary course of business, that they buy and sell aircraft? Of course not. There's no evidence of that. In fact, it's just to the opposite. We know there's no lessor involved, so what about a consignor? Well, we believe that the consignor, which is the principal, and I'll tell you why in just a second, is Garthorpe, and they weren't involved in the business of buying and selling. But even if you consider the consignee, for the sake of argument, or the consignor to be Bloomer, they weren't involved in the business of buying and selling aircraft. They were just a broker. They were just an agent helping to market the aircraft. They weren't in the business of buying and selling them, as Mr. Bloomer testified. So any way you slice it, they don't qualify for a business inventory exemption. It doesn't matter which nomenclature you may use for them. But let's take just a second and back off and look at Assessor's Exhibit J. Excuse me. Let me find it. I'm sorry, Exhibit I. This is the consolidated case that, by the way, was brought to our attention by Mr. Rice. Okay, so let's take a look at what consolidated was. Consolidated was a case in California dealing with California tax law. In this case, income tax law. The consignor was a Texas corporation that sold ladies' accessories in Texas. And they'd enter into consignment agreements with various retailers in the state. So both the consignor in Texas and the consignee in California, either way you slice it, both of them were dealers in the business of buying and selling these assets. They came in and claimed they should get an exemption from certain income tax requirements because they weren't located in the state and didn't do business in the state. And they go on to point out that the way this thing worked is they would ship the goods from Texas to the guys out here in California, who would then receive them with the right to sell them and the obligation to sell them and the obligation to collect the proceeds, and then they would send a portion of those proceeds back to the guys in Texas. Now, if you look at what they said, which I think is really important, in talking about consignment agreements, they talk about the fact that the co-signor is the principal. Well, that's Garthorpe. And they say the co-signee in this case was the agent in the state. But keep in mind, nowhere in the code does it say that the co-signee is entitled to get a business inventory exemption. It has to be the co-signor. And they go on to talk about the fact that in these particular sales transactions, not only were they given the property, but they were given the right and obligation to sell the property, collect the money, and send it back. Consignment is a lot more than agency. It's a lot more than simply acting as a broker and taking a commission. We don't have that here. And they go on to point out that the terminology in the appellant's memorandum of agreement, I'm now reading from the case at page 1040, is consistent with consignment throughout. It is expressly labeled consignment agreement. The parties to it are called the co-signor and the co-signee. And then they go on and determine it is truly a consignment agreement, and therefore they have to pay the tax. They don't get off for being an out-of-state seller because of the intermediate concept. So what we're telling you is that if you read the code sections and if you read the regulation that we've cited to you, you'll find that nowhere does it allow a co-signee to obtain a business inventory exemption, and even if it did, which it doesn't, the co-signee has to be in the business of selling, buying, and selling the property. And we don't have that here. By the agent's own admission, Mr. Bloomer's admission, they didn't buy and sell these jets. We know Garthorpe didn't buy and sell the jets. And there's no lessor, so how can you have a business inventory exemption? You can't. So all of this stuff about, well, we held it for sale and we didn't fly it, and you know, we intended to sell it, that's all good and that's all nice. It's nice that they did that, and it's appropriate that they did that. But they're not in the business of buying and selling aircraft, nor was their agent, so they don't get the benefit of business inventory exemption, even if they held it that way for 10 years. It's not appropriate to tell a taxpayer who owns a $20 million aircraft, you don't have to pay property tax. All you got to do is list it with Bloomer, and we'll argue that you're entitled to a business inventory exemption. So you can escape tax while everybody else who has their Cessna 182 or their 4-engine Trump jet, the rest of them, they have to pay property tax, but you get out of it because you say you listed it with somebody. That's not enough. It's not enough to say I listed it with an agent and I had somebody else managing it. What we saw here is that all the costs were being paid for by Garthorpe. Mr. Counsel told us that. All the management costs, the repair costs, the maintenance costs, everything that had to be paid for was paid for by Garthorpe. Even though Sun Air may have acted as an intermediary, they passed that on and Garthorpe paid it. Mr. Bloomer has testified that he was an agent and he, quite frankly, did his job. He helped them sell the property and market the property. But who do you think paid all the invoices for all of that advertising? Garthorpe. It says so in the marketing agreement. There's even bills that were provided to us that show that Garthorpe paid for it. So it wasn't like this Bloomer took possession of the aircraft with the right to sell it and the right to collect or direct proceeds, or even had an agreement that said they were a co-signee or a co-signor. They didn't have any of that. Yet they want this board, in contradiction to the statutes and regulatory requirements, to give them a break on their property tax. That isn't appropriate. That's not appropriate, and that's why the LA Assessment Appeals Board determined that it was inappropriate. It's not appropriate for somebody who owns a $20 million jet to come in and say, hey, I need a tax break to make my next movie or whatever. You ought to give us a break so we don't have to get taxed on this airplane that we had located in Camarillo. Inappropriate. So our position, very simply, is that if you're going to get a business inventory exemption, you have to qualify on each of the requirements under the law. And all of these letters that were submitted, even the ones that were legal opinions, say it's a factual determination to be made by the assessor's office, and that the taxpayer has the burden of proof, not only before this board, but also the burden to convince the assessor that the facts and circumstances warrant it's being treated as a business exemption. Whatever they did in Orange County, they had an agreement labeled consignment agreement, and the facts and circumstances in that case aren't here. We don't know what was considered or not considered or what they looked at or didn't look at, so that certainly is not determinative of what this board ought to do with different facts, different circumstances, and different people involved. So based on the testimony of Ms. Hill, who is an expert in property tax matters and who can testify about those because of extensive training and experience, this does not constitute a plane that should be classified as a business inventory item. With that, we submit it to the board.
Okay, thank you. And let's go next to the closing summary from the applicant.
Would you like to comment on the assessor's closing comments before I close?
Just that I felt that it was inappropriate for him to assume that he wants more money to make more movies, and comments like that are anti-rich have no place here, because this is the Board of Equalization. It equalizes all people in all different businesses.
Thank you, Vicki. I'd like to start by thanking you for your patience. This is, I'm sure, has been a very trying day for you folks, and we do appreciate the opportunity to be heard. That's what we asked for. We have full faith in your ability to make a decision. If your decision, we believe that you're going to conclude that we have a position and that we've documented it and we've submitted evidence in support of that position. We just ask you to think about the things that we've done. We've submitted evidence to substantiate the intent to sell the aircraft. We've submitted evidence that the aircraft was actually sold. We've submitted evidence that the aircraft was sold under a consignment/agency agreement. Call it what you like. The Second District Court of Appeals said that a true consignment is an agency or bailment. We literally have an agency in that marking an agreement, so I don't fully comprehend how the assessor can ignore that, but he's chosen to do so. We don't think you will. We presented evidence that the aircraft was not used in any way inconsistent with the rules in the property tax rules with regard to the use of the aircraft during the consignment period. And we've presented evidence to you that Bloomer DeVere sold the aircraft, this aircraft, in the ordinary course of business as he sells every other aircraft. And so I'm less than clear, again, on how the assessor can take the position that the aircraft was not sold under a consignment agreement. Specifically, there are no statutes or regulations which speak to this issue of this consignment. And so that's why we went to the effort to go to the Board of Equalization and ask for guidance, and we got some guidance. And I think that the assessor's representative is not giving due weight to the letter that was written by Daniel Paul to Mr. Lucero. I mean, those questions in that letter are directly on point to the issues in this case. And we believe that the answers in that letter are favorable to our case. And with that, we are done. We thank you for your time.
Okay, thank you. We'll close the hearing to public testimony, and the board will deliberate. Mr. Blahakis, I'm not sure what our options are in relation to deliberating. My guess is that we might have to schedule a different day in the near future to do that. But
right, it's completely at the discretion of the board. If the board felt like knocking it out tonight, you could. It's not clear if you're asking your
I think
council
my
to
question
come
is
back
what-
with any information before we schedule the meeting, but we could schedule, it would be a closed session meeting of the
Right.
board, which I would announce the decision in writing after the fact.
Okay, and should we want to deliberate this afternoon, do you have, since we're in an
I'll,
alternate location right now, do you have a place that we can do that?
Yes, we have space available upstairs.
Okay, so to our fellow board members, I would, I think we might be best off deliberating now if we have time to do that. Unless there's any objection to it. Okay, so then Mr. Blahakis, if you could help us with that, that'd be great in terms of the location.
I'm arranging for that now as we speak.
Okay, and so for the assessor and applicant, the board will deliberate and may or may not reach a decision today, but as soon as we do, a minute order would go out from the clerk, or you can check in regarding the status, and then also the findings of fact would go out during the normal time frame afterward.
Yeah, Mr. Chairman, I'm not familiar with your local board's practices on procedural matters. I appear before a number of assessment appeals boards. So,
Okay.
in many of them, the board directs either the applicant or the assessor, whoever the prevailing party is, to prepare a proposed findings. Is that what this board does, or do you have a different procedure?
Well, we will be deliberating in closed session. We'll have a lot of information to share. We may ask our counsel to get some background information regarding laws or codes, and then our decision will be followed by findings of fact that will be prepared within 45 days. Am I correct?
With a minute order going out, and if no minute order goes out, there's a longer period for preparation of findings of fact.
Okay, well, I'm just saying that if the board wants to direct us, and I'm sure Mr. Rice would agree as well, to prepare proposed findings for the board, we're certainly willing to do that. If your counsel is usually the person who does that, then we certainly understand.
Right. Our counsel generally does that, and unless there are any other comments, Ms. Porch, that you have, it's not something that we would ask for from the
Okay.
applicant and from the assessor.
Something that some counties entertain when they've made a decision, then they, the victor will typically be the one to prepare proposed findings. The other side can prepare alternate proposed findings, and then, their counsel will look at the proposals and come out with, draw upon them in drafting their findings. We haven't done it as a matter of board practice in this county.
I leave that to the board and its counsel to decide. If you want us to do so, we're happy to do so. If not, that's fine.
Okay, thank you. Okay, thank you everyone for your time and effort.
Thank you.
And we'll get you a decision as soon as we can.
You want to handle these tips while we're in?
Yep. We'll just take a break for 1 second, get our information here. Are there any stipulations, Mr. Blahakis, that we did not receive ahead of time?
Yeah.
All stipulations were emailed to the board last Wednesday, I believe it was, and there have not been any additional added.
Okay, great. So we'll go to item 18, which includes stipulations in applications 19 through 28, or agenda items 19 through 28. And we all did receive those stipulations via email ahead of time. Any questions, comments from the board? No. Okay, so looking for a motion to approve the stipulations included in item 18.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and I think rather than hold the hearing open to come back and announce a decision, we'll adjourn.
Correct.
And the minute order will go out later. So we're adjourned at 3:35. Thank you.
Thank you very much.
Thank you.
Oh, that's what he.
I do write on napkins.
I realized I didn't have any Post-its once I was relayed to this. I'm used to having a desk right there. So. Yes, sir. They've adjourned the meeting for today, so there won't be any decision announced. So we'll get it. Right.
don't know what the best option is.
Depends where the source is. The clerk of the board turned Taylor around. For Brenda.
Thank you. Okay, I have